So the origin of this first talk is the relationship in the mining code between the grant of the mining right and the contract that goes with it.
I have one small suggestion. Since we have missing participants and those are lawyers, maybe we can just change the subjects and leave the contractual part until they arrive, because I know some of them are really very interested in this, like Arthur and the one from the University Legal Center. Maybe we can talk about foreign legacy management up front and then continue with the contracts. You agree?
Առաջարկ են որ կողքել թեմաների հերթականությունը, որտեղ այս մի թեման շատ իրավաբանական թեմա է, անցնենք այդ ժառանգության հանքարդյունաբերության ժառանգության խնդիրներին, որ ավելի հաղթվածության
իրավաբանները, որոնք դեռ չեն եկել։
This is just one of the topics that you asked me to work up. So.
Yes, սա այն թեմաներից մեկն է, հարցանոթին ժառանգության կառավարումը, որը հետաքրքրություն ունի կայացրել
So this is very simple, but those are the essential things that you need to deal with mine legacy. And the first, I'm going to deal with each of them in turn. It's money, time, political will, and laws to enforce compliance.
Այս շարք կետերը շատ բարձ, բայց այս շարք կետերից է բաղկացած այսպես ասած գործողությունները, որոնք անհրաժեշտ են հանքարդյունաբերության ժառանգության կառավարման համար, որտեղ նշված է բավականաչափ ֆինանսական ռեսուրսներ, արտադրություն, բավականաչափ ժամանակ, քաղաքական կամք, այսպես ասած, եւ ավելի մանրակրկիտ իրավական կարգավորումներ։
Make sense of this routine among us. In fact, we can have a conversation more than where we could put in technical capacity.
Yeah, well, that's in the development of the laws.
Also implementation.
Yes. So it's deceptively simple. I mean, I'm making it deliberately simple. But in essence, if you don't have enough money, you actually can't do this. You cannot do the cleanup because the damage is extremely expensive to clean up. I mean, it is ridiculously expensive. And I said yesterday, there's no state or country budget that I'm aware of that has made provision for this.
Կարող շատ բարձր չի, բայց ամենակարևորը գումարների ֆինանսական երաշխիք է, այսպես արկայությունն է, ամեն ինչի հիմքում անկած։
Germany has an interesting example after your reunification.
They're doing these German mines.
Yeah, they actually used it as a job creation opportunity, which was much more successful than the American Superfund model by trying to get this to that. Գերմանական մոդելը շատ հետաքրքիր է, որտեղ դրանց միացումից հետո օգտվեցին այդ աշխատատեղ ստեղծելու պատճառաբանությունը օգտվեցին եւ հանքերը բավականին բարելավեցին իրավիճակը։ Բայց ամերիկյան մոդելում է սուպերֆոնդի մոդելը, որ ստեղծվել է, ինքը ահավոր թանկ եւ շատ ավելի կամաց պրոցեսական թե գերմանացիների կառավարության կարծում ընթացքում շատ ավելի կառավարության կառավարել իրենց legacy ժառանգությունը։
When I was working for East Timor, we put deliberately high fees in because they haven't got any mining at the moment. We started from the beginning raising money to pay for abandonment because there's a feeling that that's going to happen because companies will come in and then just go bust. And they're trying to put the structure together to stop that. But there's been a kind of pragmatism about the fact that they're going to end up having to pay for the cleanup.
Հարավյան Թիմորը երբ որ ասում այնտեղ ոլորտի նոր է սկսում չի եղել հանքարդյունաբերությունը հանձնվեց ու որոշեցին, որ այդ սկզբից բացը չափով վճարներին սահմանելու, իմանալով, որ շուտ է ուշ լինելու են խնդիրները, հաստատ գյուսումներ ստանալու են, ու կմնան իրենց կարգ
Western Australia is the first state, as I said yesterday, that's had a plan to start to clean up the mines. Queensland has no plan, no money. They have a unit of 3 people that deals with the 15,000 abandoned mines. So there's no political will there to fix things.
Արևմտյան Ավստրալիան առաջին ժառանգության կառավարման հարցում մեխանիզմները ստեղծել, Queensland-ում որտեղ է այնտեղ միջին լավ չկար քաղաքական կամքը դա անելու։
3 հոգի աշխատում է 15,000 լքված հանքի կառավարման սովոր անիմաստը։
One of the things that you have to do is to design payments at the time the money is being made, because if you don't, there's never any provision left at the end.
Ամենակարևոր բանը որ պետք է անել ժառանգության կառավարման հարցում նա այն է որ ստանալ այդ գումարները կառավարման համար այն ժամանակ երբ հանքարդյունաբերությունը եկամուտներ է ստանում։
Եթե բանը չանենք, ասում այլ արդեն անհնարին է գումար։
So the striking the balance, and I mean whether I don't think it's been struck here at all well, but I don't think that's the point. I think you've got to try and you've got to create a policy framework that enables the money to be paid as a tax or as a fee or something at the time the money's being generated. If you lose that opportunity, you won't be able to fund the cleanup. Now, the laws here now are designed to ensure that the cleanup is the liability of the miner. And you know, the problem is, as we've identified, there's not enough detail to get the miner to do the monitoring, and the drafting is aspirational.
Կարգավորում են այդ հարցերը, սակայն այն ինչ որ բացահայտվեց հանդիպումների և մարդկանցից ընթացքում նա է, որ բավականաչափ մանրակրկիտ չեն կարգավորումները, որպեսզի հասկանան ինչպես են դրանք։
So if you're creating this system to capture the money up front, the state will be reluctant to really hit the miners hard because they're attracting investment, they want to make an attractive place to invest, they don't want to hit miners up with too many taxes. And the miners will complain, they always do, that they're paying far more tax than anybody else is. That is a standard approach of any miner going into any country, is you need to lower the taxes for me. Well, that's the problem, is that the desire to create a sustainable industry requires the capture of some money as it's been generated, but there's a pressure not to do that from the miners and shareholders of the miners who are saying, oh, give us a holiday on those payments because this is a very risky business, and the first 2 years we don't earn any money, and the structuring of the industry is such that capital flows start much later than the required capital payments.
Ընկերությունները դրան հիմնականաբար պատկանել հավանություն չեն տալիս իրենց համար կարևոր է սկզբնական շրջանում հակառակը հարկերը ադմինիստրացիոն։
The impression that I've gained in the very short time I've been here could be completely wrong, and it may be a posture that the government officials that we've met with don't seem to be trying to avoid, they don't seem to be against having a responsible sector.
Այն տպավորությունը, որ ես ունեցա շոկ արժանինական հատվածում, գուցե եւ դա այդպես չի, բայց պետական պաշտոնյաների հետ հանդիպումների ընթացքում հասկացա, որ իրանք դեմ չեն պատասխանատու հանքարդյունաբերության հիմնական այսպես սկզբունքներին.
The problem is that the legacy is so bad.
Խնդիրը ուղղակի նրանում է, որ ժառանգությունը մնացած է, անցյալից այնքան վատ վիճակում է.
That there's very strong arguments to put that mining shouldn't happen at all because it's not been well managed in the past, and how can we make sure it doesn't get managed in the same way in the future?
Այնքան վատակառավարվել նախկինում եւ հիմա ներկայումս կառավարումը, որ դավախություն կա հատկապես տնտեսական հասարակության մեջ, ասես ես հիմա ասում, որ մենք չենք կարողանալու պատասխանատու հանքարդյունաբերություն ունենանք Հայաստանում, որ այս There's no trust in the system, no matter how well you present the case for responsible mining. There's no trust. The mistrust is based on what people see in the
And I think, though, that what the government will be being told by companies like Lydian's a good example, is that it is possible to have a responsible approach to mining. And I know we were getting a sales pitch the other day, but if they are doing these things that they described, then they're doing the sorts of things that happen in best practice jurisdictions. The pressures to cut miners some slack, does that mean anything to you, that expression? The definition, yeah, so that desire for miners, where miners ask, give me a break on the money, on the royalties, so that I can get this project up, will benefit you. There's a very strong pressure on governments to do that, even in a developed economy. So the pressures in a developing economy are even greater to create, to get the mine up and get the jobs going, because it's not just the direct investment that turns you from a developing to a developed economy. It's all of the indirect effects that flow through for the jobs and the payment of income tax by individuals, and the creation of a sector to service the big mines. That all creates diversification of the economy and turns you from a developing nation into a developed one. And the difficulty for the government is that will be for some time their primary objective, is to stabilise their currency, to try and get inflation under control, and the way you do this is by getting these kinds of projects up. So the pressure here to give these kinds of holidays is even greater. Now there's also a counter pressure. There's also a counter pressure because the state wants the revenue, and the royalties are revenue. So there's a negotiation going on.
Դա արկա է, նույնիսկ շատ զարգացած երկրներում, եւ այդ ճնշումը շատ ավելի մեծ է եւ նկատելի զարգացող երկրների համար, բայց այստեղ նույնություն կա զարգացող երկրներին պետք է այդ ուղղակի ներդրումները ուղիղ ոչ միայն ներդրումների տեսանկյունից, այլ որ դա հնարավորություն է տալիս նաև աշխատանքների ստեղծման համար, այսպես ասած, արժեքային շղթան, հա, հանքարդյունաբերությունը ստեղծած եկամուտների շնորհիվ արժեքային շղթան ընդլայնել եւ ընդհանուր տնտեսությունը զարգացնել եւ դիվերսիֆիկացնել։
Իսկ պետբյուջեի վերածություն։
Այո, պետբյուջեի վերածություն։ Միայն ուղիղ ներդրումները չեն, որ ապահովում։
So it's going to be difficult to create a level of trust while those pressures exist.
Level of trust
between the civil society and the government about mining.
Շատ դժվար է լինելու այս ճանաչումների եւ ամբողջ կոնտեքստում ստեղծել վստահություն, քաղաքացիական եւ պետության միջեւ։
But we mustn't be under any misapprehension if the government isn't careful, it will get protests. It will get people picketing mines, it will get people chaining themselves to equipment, chaining themselves to trees, trying to stop the mining from happening. Because it happens in Australia, it happens in the US. There's a massive Indian protest against the gas pipeline in South Dakota at the moment. Just a massive, or North Dakota, a massive protest going on about the pipeline. So.
Եթե կառավարությունը այդ ամբողջ գործընթացները բավականաչափ զգուշությամբ եւ խելամիտությամբ չի իրականացնում, անխուսափելի են պրոտեստները եւ բուզումները քաղաքացիական տեսանկյունից միշտ կլինեն մարդիկ, ովքեր կլինեն դրանց միջոցների, դա օրինակ
North Dakota, it's a state. Those kinds of protests now have a global reach. The fact that I know about it is because of Facebook.
Me too. My sister's involved.
Yeah. So that's the breadth of the protest can be global very, very quickly, within hours. Morning.
Սեփականություն փոխել ենք, առաջ ժառանգության թեմայով ենք
Whenever you feel like you've said what you know.
She's a lawyer?
She's a graduate from political science. You can introduce yourself.
Yeah, I graduated in May this year, and I'm working in CRM from February.
Where are you from? AUA?
Yeah.
So we decided to change the order because some of the legal stuff we thought you would want to hear. And so we're doing mine legacy management at the moment. We're just talking about the relationship between the state in any jurisdiction and the mining companies that are investing in that jurisdiction, and how that relationship can be a very cozy relationship, or it can be principled. but it often is cosy because the state wants the revenue.
Sorry, saying legacy, you mean only the left mines, so-called left mines, or tailing dams as well, which can be
Anything, any legacy, tailings dam as well. So we're just talking about the fact that
waste rock or whatever.
any leaching.
Ոչ թե միայն ճամբար, նաև այդ բաների բացկապահ ինչ են ասում հայերեն։
Բացման։
Դա բան է, այդ սկզբնական այդ կարևոր համն
Բացման։
Դրանք էլ այդ ժառանգության մի մասն են կազմում։ Իրանք էլ սկսում են ազդել
So, but I think that if you're going to be fair, governments are often doing this because they're trying to develop the economy, and they know that prosperity will deliver them votes, which will deliver them power. So these projects directly influence the political process. And I don't mean that it's necessarily corrupt influence, it just is part of the mix that goes to inform the politics of every country. So this is not something that is peculiar to Armenia. This is the same in Australia. And in fact, there's a massive debate going on in Australia at the moment because a former mines minister, national mines minister, has become a lobbyist for the mining industry. And so there's been this terrible suggestion that this is what he's been like all the time, but he's been captured by the industry.
Միշտ քաղաքական այսպես ասած կապեր եղել են հանքարդյունաբերության ոլորտի հետ այն տեսանկյունից, որ քաղաքական գործիչները ցանկանում են հանքարդյունաբերության այսպես ասած շնորհիվ ստացված եկամուտներով եւ աշխատատեղերի ստեղծման միջոցով ձայներ ապահովել, իրենց շահերը առաջ տանել, պարտադիր չի, որ դրանք կոռուպցիոն ռիսկեր պարունակեն կամ կոռուպցիոն կապեր լինեն, բայց այդպես է, օրինակ իրենց մոտ նախկին հանքարդյունաբերության ոլորտի նախարարը պաշտոնից հետո դարձել է հանքարդյունաբերության ոլորտի լոբբիստ,
And one of the pressures that exists in a developing economy that doesn't exist in a developed one so much is that the money that is secured in royalties, even if there is a policy to devote some of that money to clean up or to make a company pay for a clean up, there's a great pressure if the money is collected by the state to clean up that the state won't use it for that. And I think you've had that experience here in Armenia. Where there's money available, but it gets thrown into some other pot and used for something else.
Ժամանակ ոլորտիների հարկերի շնորհիվ կայացած խմբարները, որոնք պետք է ծախսվեին նպատակային ժառանգության համար կամ նպատակական աշխատանք կատարելու համար, ճիշտ է հավաքվում են, բայց լրիվ այլ նպատակներ են ծախսում, օրինակ մտնում են այդպիսի նախագիծ, բնապահպանական հանք, օրենսդրության ֆոնդում կուտակված գումարները, որոնք վճարվել էին որոշակի ընկերությունների կողմից, պլանավորվում էր լիազորմանի ըստ հայցողության օգտագործված հանքերում բնապահպանական աշխատանք կատարելու համար.
So the last dot point there is really the proposition that we're trying to work out here, and that is how can we deliver prosperity while ensuring that the investment is sustainable. That's really the difficult. And it's not, as I say, it's not peculiar to Armenia. I mean, that's the problem for every developing and developed economy.
Շատ կարևոր է այդ բալանսը պահել, ինչպես կարելի է երաշխավորել եկամուտները, եկամուտների կարողությունը նաև կայուն ներդրումների միջոցով.
So this is where the EITI initiative really fits, because you're trying to understand what money flows are happening between the mining company and the government, and where the money's being used and what is happening to it. And so this initiative is sort of fundamentally important to build the trust you need to be able to persuade people that having a responsible sector is possible and can be managed. So that some of the legacies that I've seen from World Bank reports and other documents, that some of the legacies you've got are really difficult. They're very, very expensive to clean up and they're very hard. So this is why when I talk about time, you actually have to start the management of the legacy before the mine's even started. And that's why mine closure planning has become part of your scheme, and it's got to be done before the mining right is granted, or at the time of the mining right being granted, and it's part of your EIS, and that is best practice. So you've got that structured into your law now. The thing is to make sure that it actually happens. And that's when we've been talking about lack of depth in the laws, the problem is you can have a mine closure plan, but if no one's there to enforce its compliance or to check and audit that it's being followed, you're going to have legacy problems.
Ժառանգության կառավարումը պետք է սկսվի նախքան նույնիսկ շահառուությունը այո դա եւ դա պարտադիր պետք է ներառված լինի շրջակա միջավայրի վերահսկողության գնահատման հաստատվելուն եւ դա պետք է կարգավորվի եւ ժառանգության կառավարման հետ կապված հարցերը պետք է կարգավորեն շահառուության դիտումության համակարգի
And I know that this planning process has only really just kind of become part of your law in the last couple of years. But that's not inconsistent with what's gone on around the world. Queensland has only just brought in social impact assessment laws in the last 3 years.
Շատ տարբերվում, օրինակ Queensland-ում, Ավստրալիայում միայն վերջերս է սոցիալական ազատության գնահատման գործընթացը մեխանիզմները ներառվում.
And it's largely come in because of some massive developments in LNG, liquefied natural gas.
Նական գազի, հեղուկ նական գազի մաները
Նախանկազաբերեցնում են և հեղուկ բանը կազին։
Այդ ինդուստրիան սկսելու համար այդ խնդիրները առաջարկի։
Սեփականային
Չէ։
Ուղղակի բնական գազը խտացել է։
Բանը խողովակը տանում են բանը։
Կոմպրեսատորների մեջ է։
Ու հետո բանը նավով տանում են։
So the reason that liquefied natural gas generated the social impact assessment laws that we've now got is that it was coal seam gas that was being used to fuel these plants, these gas plants. And coal seam gas has a much lower flow rate than conventional natural gas. And so there were, instead of 3 wells per project, there were 3,000.
Պատճառը, որ հեղուկ գազի արդյունաբերությունը խթան է հանդիսացել որպեսզի սոցիալական ազատության գնահատման մեխանիզմներ ստեղծեն, նա է, որ
ասվել է գազը հանվում է Ածխահանքի sense շփվածներից չէ ու ոչ թե ասենք մի երկու տեղ պետք է որ անես այդ բանը 3000 տեղ պետք է անես այսինքն շատ է ասացությունը միջավայրի
Ես սոցիալական ազդեցություն ասում եմ что միայն նախապատկական ասում
Սեփականության պես բան է ինքերենս
ապա ջուր չեն օգտվում
Բայց հողը շարունակում հողը նույն ձև ախտություն է չէ ինտերակտոր
կարող
So there's the gas fields are all in here and the plants are here and there's a pipeline here. Instead of an ordinary project having 1, 2, 3 wells like that, there are wells all over this area. And this is, you're talking about, this is probably 1,000 kilometres of area from east to west. And you're talking about, at the end of the life of these projects, there will be 19,000 gas wells over all of that land. And so you can imagine the social impact of that. It's massive. And it's the only thing that forced the state to bring in new laws because of the size of the development was a difference in kind, not a difference in degree from other projects.
Լայն 10 կիլոմետրի խորհրդարերի եւ ասեն սոցիալական հասարակությունը շատ մեծ է քանի համայնքներ Եթաշնորհի ստիպված նորենք հանել
նպաստել է սեփականության
So this is these are things that are happening, you know, in the last 5 years in a developed, responsible mining country.
But I have a comment about that. Australia maybe can't allow itself to do it because of its huge territory, and there can be different areas where can be this kind of activity, let's say for desert area or in not inhabited area. In case of Armenia, it's very small.
This is the best agricultural land in Queensland.
Oh, I'm sorry, but still.
So you had a direct clash between miners and farmers, and in fact, I'm talking about this in detail in my lecture tonight. But it's the best farming country in Queensland.
So has there been effect on the water?
Massive, and there are 4 projects. So there's massive cumulative impacts on the groundwater, and they've now had to bring in all these laws to insist on the companies managing the cumulative effects. And they've had to, I think I was talking about the other day, that they've had to force the companies to sit and talk with each other about it. And they're all in massive competition with each other because they're selling LNG to the same players.
At least that's not vital, you know, it's an issue of business. In the Armenian case, it can be vital because there is no space to live anymore.
Tell the farmer that.
Yes,
it's not vital to them.
It's vital for
Yeah, it's very vital. So it's the same issue, it's exactly the same, and you have every right to be concerned about it because there's a lot of people in Australia that are very concerned about it as well. So it's not, I'm just trying to give you, I mean, you'd think there'd be a big contrast between the countries, but there really isn't. The issues are exactly, the politics of this is exactly the same.
Արդյոք տարածքների տարբերություն չէ Հայաստանը Ավստրալիան համեմատում Հայաստանական փոքր է եւ նման գործունեությունը նույն Հայաստանում ծավալելու պայման դեպքում շատ ավելի լուրջ հետևանքներ կարող է ունենալ, բայց պատասխանը նա է, որ այդ տարածքը, որտեղ որ հորատումները ունեն ունենում, լավագույն գյուղատնտեսական հողերն էին եւ շատ մեծ այսպես ասած պայքար կար
Թեմանե եւ
Ֆերմերների, գյուղատնտեսության զբաղվող մարդկանց եւ խաղաղարարությունը, այսինքն այդ կապ չունի տարածքի մեծությունը, փոքրությունը, միշտ այդ խնդիրները արկա են։
Եվ իհարկե ջրի քանակի վրա ազդում է։
When you talk about enough time, this project had a 2-year development timetable, so the community from 2009 to 2011 had to digest 4 11,000-page EISs for the 4 different projects. 11,000 pages. All with little or no understanding of coal seam gas, no understanding of liquefied natural gas, no understanding of pipeline construction, no understanding of the impacts on the groundwater. It was all in the EIS, but there were 4 of them, and they all looked at different aspects of the groundwater because there were slightly different areas that they were, they're all next to each other in that area.
Եվ ինչի են հասել։
Ուղղակի համայնքն է ընդամենը դավաժանքետ ունի, բայց եթե ամեն ինչ մասեն հասկանան, իսկ համայնքն է միջև է ընդամենը չգիտեն այդ խնդիրների մասին, չգիտեն այդ բանը, հեղուկ գազի ինչ բան է, կողովակի կառուցման խնդիրների բանն է եւ այլն։ Այսինքն այնուամենայնիվ sovereign.
All the plants were built. So there are 3 natural gas plants in Gladstone now. Sorry, liquefied natural gas plants. The plants essentially freeze the gas, put it onto ships, which are large freezers, and the ships take it to Korea and Japan and China, and then they unfreeze it and use it for energy. Translate that if you can.
Much cost.
SARS must be Japan, Marvel, Korea, California.
Is it even effective?
It costs, if you build one of these things, and you're talking, I think, something like $8 billion to build each of them. Right? So this is a big project. But to have 3 of them, it's like, altogether the capital cost for the 3 of them is $60 billion.
I cannot understand such things because Australia is a sunny country, there can be solar panels,
It's not for insurance.
It's not, no, it's all being exported. It's all going to industrial use in Korea and China and Japan.
So $20 million
Sorry?
$60
billion for all of them. The three. Well, you can work it out. They're making probably a 48 to 50% return. They make phenomenal money. But the risk, it's such a risky business because they identified this supply and demand problem back in the mid-2000s. And so they all scrambled to fill the demand with these new plants. And the demand curve suddenly collapsed because of the 2008 crash, global crash. And so they all had to slow down a bit so that the economies could come back.
It's still making a profit.
They'll make a profit later, so they won't have done as well as they would have liked. That's no one knows, but that's what they think the return is. Otherwise, you wouldn't take the risk because there's so much money involved. If you turn one of these plants off, it costs $2 billion to turn it back on again. So.
Բայց բան է, հետո 38 թվականին բան է չպնժամ է եղել, պահանջարկ իջել է, հիմա պետք է վիտանդաղ մատակարարենք այն որ պահանջարկ չի, բայց էլի չան կստանա։
The point I want to bring it back to though is that the communities had almost no ability to deal with this. You know, from a social impact perspective, these are really, really complicated projects, and to have 3 of them, you know, at one point there were 4 of them proposed and dumped on them like this, it was very, very difficult. And even if you, as you've now got social impact and health impact assessment processes in your laws. You think about it from a community perspective. If suddenly there's a mine proposed for their backyard, they don't know anything about it. They fundamentally don't know anything about it, and they've got to start from behind the 8 ball.
Yes.
So I guess what I'm...
Let me just translate that. Շատ կարևոր հանգաման կա, որ նման բարդ պրոյեկտները եւ իրանց սոցիալական, բնապահպանական եւ առողջապահական ազդեցության գնահատումը այնքան բարդ փաստաթուղթեր են իրան, որ չի կարելի ռեալ սպասել, որ համայնքը կկարողանա ընկալի եւ հասկանա ինչ խնդիրներ կան։ Եվ սա ընդհանրապես EIA, ESI process-ներում խնդիր է ինքը, շմագի process-ներում խնդիր է, համայնքը ինքը պատրաստ չի այդքան տեխնիկական ինֆորմացիա յուրացնի։
So what that means for legacy management is, I guess the point I'm trying to make to you is that the best guard against bad legacies is community involvement very early on, but informed involvement.
Մենստավ պաշտպանը ժառանգություն չունենալու համար այնա որ համայնքը սկզբից մաս կազմի process-ին, բայց համայնքը նաև իրազեկվածն է։
In many cases, it's again problematic because of the poverty, and communities often they even understanding, having in mind that there can be this social impact. They say, okay, just give us jobs, just some amount of salary and social improvement. That's another issue in our environment in our case.
And that's no different to these farming communities. It's not that they're necessarily poor or uneducated people necessarily. It's that these are really foreign to these projects. They're a big mining project has a lot of scientific data attached to it, a lot of difficult concepts attached to it that, you know, when you're running a farm, you don't need to know about. But you've got to somehow get brought up to speed with the complexity of it, and then try and make an informed decision about it. So you need more time early on for a community, but because the community is the best sort of pressure point to get the miner to do something that is not going to cause legacy problems.
As to the time frames, by the way, you talked about 2 years time frame, right?
Well, that was from the time they really arrived in the country to the time they had to try and have financial close on their, you know, say, well, we are going to do this project. That sort of point was that they had a very aggressive timetable because of the demand curve for LNG. They subsequently pushed that out because of the global downturn in 2008. But yeah, there was initially they were kind of, you know, hustling people.
Still, it is some time, but in our case, the time frames are too much tight. I mean, totally 180 days, 6 months. It is the most, I mean, the largest amount of time defined by the law. In order to starting from the start of the project, initiation of the project, up to the end. First, in the middle, there is a time when the company presents its environmental impact assessment, but if they bring it early, the expertise shall pass too quick, and it's again not much to do logical.
But that does not mean that the government or the reviewers cannot say, I need more information, go back. Within the 160 days, they have to request, they have to review and make their comment. And the comment could be, I'm not ready to approve it, bring me more information. Right?
That happens all the time in Australia.
Վերջնական եզրակացությունը
that's cheap. No. In the law of environmental assessment, it's defined that there can be 4 types of decisions. And one of them is not that one, that you bring more information, I cannot. But I don't remember correctly, but it's a little bit different. Among 4 types of decision, one can be rejection, one can be okay, green light, and 2 others are a little bit different, but okay, maybe I missed it.
I think, you know, the industry is also very sensitive, because I know one time you got into an argument with the industry in one of our meetings.
Շտկելու են դեպքերում, երբ որ տվյալներ չկա, մեզ մոտ նույնիսկ եղել են դեպքեր, երբ որ ասենք թե դրա մեջ պետք է բերեն բնակչության առողջության վիճակի տվյալներ եւ այլը, նույնիսկ մեր մոտ բան են արել, կողքի ելակետայինը այդ գյուղում, որտեղ որ պետք է լիներ չկա, վերցրել էին կողքի գյուղերի ինչ-որ բնակչության առողջական բաները ու արհեստականորեն մտցրել էին այդ բանի մեջ, մինչև որ նորից թեղուտի բանի մասին է խոսքը գնում, մինչև որ նորից փոխել չտվեցին այդ բաները, հետազոտեն հետո, այսինքն եթե մեր մոտ մի քիչ այլ ձևով են թեղուտի, այլ ձևով են մոտենում այդ հարցերին։
For example,
the issue wasn't Kevin specifically. The issue was, you know, it's how the process. They can ask for more information, and there can be time for them to. In the one instance, for instance, the company had presented. They couldn't find facts on the community that was being impacted. They presented facts from.
Reasoning by analogy, that is. One of the things I've never seen happen, but I don't know why it doesn't happen, is getting the state to require in the laws a miner to hire a technical expert for the community, so that they can.
Համայնքի համար տեխնիկական փորձագետի վարձ աշխատանքի վերցնի. And what the technical expert is supposed to do?
So this happens quite regularly now in native title negotiation in Australia for a big project. So that the traditional owners insist that the miner pay for their environmental technical expert to explain the EIS to them.
Տեխնիկական փորձագետը, բնապահպանական հարցերի տեխնիկական փորձագետը հիմնականում լինի համար, որ համայնքին ավելի մաչելի ձևով բացատրի ամբողջ բնապահպանական ազատության գնահատումը։ Մեզ մոտ այս ծավալակի թղթեր են վերում ներկայացնում 4 փուլով քննարկում եւ վերջ։ Այդ այնտեղ մեծ վերում, հատուկ մարդ են բացում, որ ինքը դրա համայնքի ծավալակի։
Լավագույն դեպքում գյուղապետարանում հավաքում են մի քիչ իրանց մարդիկ, ովքեր
մի քանի տնօրեն
իրանց պաշտպանեն, իրանց ասած անցկացնեն, դրանով վերջանում ամեն։
Հայաստանի պարագայում քարում ասում էր, որ ով վճարում է նաև խոսք իրանն է, բայց ինձ կա լուրջ հնչյուններ, որ կարողանանք անկախ մեխանիզմներ մշակել, որտեղ այդ անձնավորության ընդունությունը համայնքն է անում, բայց գումարը պարզապես հանքարդյունաբերողն է, իրանց պարագայում։ Եթե նման այդ ընտրելու process-ը անկախացնել վճարելու process-ից կարող ամեն մոտ and separate kind of the selection process from the payment process. Չի գալի որ համոզի ես լավ թե վատ պրոյեկտ է, դա իրավունքության դա չի։ The function of this expert is not to convince that it's a good or a bad project, just to explain the science, the facts behind it.
And the miner could be told to pay the money to the state so that the state pays for the
Is it an independent expert?
Yeah, absolutely.
How much now?
Paid by the miner. So the same happens with lawyers. The same happens with lawyers. the minor pays for the traditional owner's lawyers. Now, there's that sounds like a conflict of interest, but it doesn't work that way. The lawyers are required to give their clients, the traditional owners, fearless advice. So it doesn't matter who's paying them. And as you say, Alan, it's not the expert's job to advocate the project. That's the minor's job. The expert's job is to explain what is being advocated to them and to ask questions about the project so that the community's interests are protected. They call it, if you like, a community advocate.
There have been cases where the community itself has paid for an expert?
Yes, in central Queensland they did that.
And if you compared the quality of inputs?
If the person's a professional, they'll do their job properly. And as I say, it's never been a problem in Australia.
In criminal justice, sometimes you get this impression that advocates who are paid by the government to represent penniless clients in criminal cases, they're not particularly, they're not trying that hard. They're not trying as hard as a lawyer who's been paid by the government.
Yeah, I think, as I say, it has worked very well in Australia. So it's certainly something that you could put into the mix here, I think. Because otherwise, how does the community get up to speed? If the EIS is, even if the EIS is only 2,000 pages, it's still, who's going to read 2,000 pages?
If they do read, they don't understand.
Exactly.
Yeah. I read some 200-300 pages of Kajar and Mani's EIA. It took me 3 days to read these 3 pages, and I just skipped the technical part.
I know, because it's gobbledygook.
3 days for preparing these 2-3 documents, closure, EIA, and etc. I can't imagine 2,000 pages.
So that, I know that there's a time frame in the law for assessment, but the community should pressure the minor to give them as much time as they need to get their heads around it, because the community is the best weapon to stop legacy problems. Because the community, if it's properly resourced and it's got the right advice, it can say, we're not having that here, you've got to fix it.
And do you have a fixed period for EIAs in Australia?
So sometimes you only get like 20 business days, which is like a month to review it in public.
Not review, do the assessment.
No. The assessment process takes 1.5 to 2 years. The preparation of the EIS takes 1.5 to 2 years.
20 days.
But then it gets released, public notification, it comes out in 20 business days.
What about the involvement of different stakeholders in the review process? I mean, community, civil society, other interested persons like farmers, etc., academic institutions. Who gives the permit? In Sweden, for instance, there is an environmental court, and everybody goes around. It's talking about this project. Everybody presents its arguments, its facts, and then the court gives decision. And what about the case?
No, it's decided by a ministry, but there's a full public process involved in it. That public process is reasonably exhaustive.
Exhaustive in 20 days,
No, because the consultations go on for 1.5 years before the 20 days.
So then 20 days to decide whether you want more documents.
Well, you've had the draft parts of it sort of circulating, and then there's a sort of formal period at the end. But there's been consultation on all aspects of it well before that.
There is no consultations and review by stakeholders in that formal period. There is no.
Yeah. Sorry, that's the time to make a submission.
Yeah.
But they've had the document for a reasonable amount of time.
Dafür gibt es nici, also înseamnă față pentru care mecul că este taskul pentru fi, înseamnă tale se na că se e to veșna că nu se duce de asta. Să nu va taskul.
1.5 years to 2 years.
Or 1.5 to 2.
1.5 to 2.
Okay. This much time needs to understand the whole project from different aspects. In our case, it's not that. In our case, it takes a very small amount of time.
They could. We need to know the law. Շմագը զեկույց այդ մշակվում է, մինչև այդ հանրությունը մաս չի, որևէ review չի լինում, որևէ մեկի միջոցով։ Չէ, մեր մոտ եմ ասում։
Ոնց չի լինում, հանրային քննարկման 4 փուլը լինում է հենց գնահատման ընթացքում։
Այդ առաջին երկու փուլը, որ կոչվում է նախնական, sorry for
our
առաջին երկու փուլը, որ նախնական է, ինքը քննարկում է շատ մակերեսային բաներ, ասենք հայտ ով որ ներկայացնում է, իր հասցեն, նախագծի վրա մակերեսային տեղեկություններ եւ այլն, okay։ Դրանից հետո, երբ որ այդ նախնական գնահատումը կամպանիան ստանում է կանաչ լույս, ասում է գնա շմագը։ Այդ շմագը, որը կարա 3000 էջ լինի, ամուսարի պարագայում, կամ 9 հատոր ոնց որ թեղուտի պարագայում, կազմում ընկերությունը կարա 3 տարում կազմի իր գործն պայմանական անցած։ Այդ չենք հաշվում որպես process։ Իր համար, իր էքսպերտներով, իրավանում գնում կազմում է։ Հենց որ ինքը փաթեթը կազմում է,
այդ փաթեթը կազմելու ընթացքում որևէ խորհրդատվություն չկա։
Չկա, ոչ, բացարձակ, ինքը
So there's 4 public hearings. One of the public hearings is to just the first one that presents the applicant, what it is supposed to do, and then the decision whether they need an EIA or not. Yes, EIA, right? And after that, the company may take a year, we may take 3 years, 5 years, whatever, to prepare the EIA. And in that process, there is no public consultation. And I think that's what's different in Australia. Yeah. And then the final 3,000, 5,000 page or 10,000 page report is presented, and there's 160 days, 180 days to review and comment.
And the first stage, I mean, this when the company goes and does its environmental impact assessment, it's not publicized, it's not discussed, it's their own deal. They do whatever they want, however they want. After they present this amount as Alan told, after that starts the time defined in the law. 180 days is the upper amount to review the whole process. It includes public hearings, expertise procedures, etc.
Ավտորիթը չեմ սխալվում, ըստ հանրային քննարկման կազմակերպման կարգի արդեն որ 7 օր առաջ հանրային լսումներից առաջ 7 օր առաջ կայքում տեղադրում են, որ մենք այդ մասին կոնկրետ ինֆորմացիա ենք իմանում ու վերջնական զեկույցին հաշվետվությանը հնարավորություն ենք ունենում ծանոթանալու կարծիք հայտնելու։ Մինչև այդ ոչ մի այդպես քննարկումներին մասնակցելու եւ այլն ռեալ բաներ
7 օր նախ հայտ են տալիս որ եկեք էս օր էս իստեղ քննարկում 7 օրից հետո ուսումնասիրում գնաց քննարկում
And they have to post
քննարկումից հետո 15 օր ժամկետ ունեն
7 days to
մինչև կարծիք 10
for the public hearing.
հա 15 օրը հետո արդեն այդ process սկսում է 60 օրյա ժամկետն է գալիս բանի որը կարա եւս մի քիչ երկարացնի
all I'm saying is that the period for the EIA in Armenia are more or less in compliance. I mean, the timing for the whole EIA process is more or less in compliance with the model in Australia.
It's just that you don't have that continuous engagement.
Continuous engagement, and we have very short consultation periods. We do have for public hearings, but they work very inefficiently because of the time periods. They have opportunity to present their
In fact, we have
But
7
that's a very
days.
different system. It's not, I mean, we're saying it's in compliance, but it's very different. It works very different.
Total ժամանակահատվածների մասին է compliance. Ինձ միշտ թվում է, որ EIA պետք է շատ ավելի երկար լինի, օրինակ US-ում ինքը open and bad է։ Բան չկա, իսկ իրանց մոտ 11.2 տարի է, մեզ մոտ էլ ամենատարապես կան։ total EIA։
Այո, հենց որ կամպանիան ներկայացրեց բանը, շմագը, հենց այդ հայտը ասեց քաջարանը հրապարակեց, ասեց եկեք իմ ճաշարանում քննարկում ենք շմագը։ Այդ պահից սկսած տևում է 180 օր, 7 օր ստեղ, դա սա հաշվարկած է, 7 օր ստեղ, հետո 15 օր դրանից հետո բաների համար, հետո 60 օր պլյուս 15 օր բանի համար, այդ մյուս քննարկման համար, That's
Russia legislative can for
դրանց դու գալիս է 4-րդ համարային քննարկումը, ելի ինչ որ ժամկետները տոտալի գալիս է
process very short period of time by lay community.
Ժամկետները տրված են օրենքում ում համար, ընկերության համար, թե պետության
Չէ, պետության ընկերությունը ոչ մի խնդիր չունի, երբ ուզի կարելի
Եթե պետությունը բան չի տալի, ուրեմն ընդունում է, որ պետության
չես տալիս, այո, կարծիք
եթե չես պատասխանում ասենք 30 օրվա ընթացքում, ուրեմն դու դրական կարծիք
This is ridiculous. I talked with Ջոնաթան about that with the state.
Soviet system, no?
Yeah, the state limits itself with the deadlines.
Որովհետև նույն պետությունն է, nույն
And if they don't meet the deadlines that they have set for themselves, it's considered yes, to be given a positive.
That's a common approach, and even in the U.S. you have that. If you don't get an approval by the state, they automatically. It's to work against bureaucracies.
If within the 30 days they say we're still considering, can't they extend the time limit?
I mean, they would have to do some formal procedure to extend the period. I mean, they have to ask an inquiry, put something
Yes,
in.
if they have, if they need supplementary information or something is missing, yes, they do have.
The 30 days is for
review
cases where there's just silence. You've submitted something and you get no response at all. 30 days pass, you assume it's approved. Because otherwise you wait forever.
And I think not really, but the time frame which is taken for the time of review, I mean the expert is 60 days, 16, not 30 but 60 days. There's only one requirement for the company that as far as he's got this license to do review, he should get it during 1 or 2 after it got the permits, the company have to start its activity within 1 year. If it doesn't start within 1 year, this permit is considered null and void.
I think it's Ontario in Canada that only has 3 or 4 people doing these assessments, and there are multiple proposals. So this is not like peculiar to here or Australia. I mean, this is a funding issue to enable there to be enough time to make these things happen. And this is where the weakness I was talking about in getting enough money together to do these things. The first part of the talk is the money needs to be applied early enough to make it cheap enough to not have a legacy problem. It's always cheaper to do things earlier rather than later. And if they funded the state departments that are assessing EISs better, they would have less problem. And the cost of the legacy far outweighs that policy cost, far outweighs it.
Ավելի վաղ փուլում է, մինչև շահագործումը կատարված բոլոր պատշաճ գնահատումները եւ հաջորդի պատրաստությունը շատ ավելի ծախսի տեսանկյունից խելամիտ է, քան այդ ամեն ինչը կատարել վերջում եւ հենց մենք խոսում ենք ժառանգության մասին, ինչը հանքարդյունաբերության ժառանգության տեսանկյունից եւս նախնական փուլում արված բոլոր գնահատումները եւ պատրաստությունը շատ ավելի մեծ ծախսերից երաշխիքների
I think the gist of what you're saying is that it is worth investing in procedures, processes that prevent the creation and use all the levers possible to prevent the creation of legacy sites at the beginning. Հիմնականում իրախորհուրդը ասած նա է, որ արժի տնտեսապես եւ ընդհանրապես արժի, որ բոլոր քայլերին դիմել, որ նախնական этапներում բավարար քայլեր ունենանք, լծակներ օգտվենք, որ այդ խնդիրը ընդհանրապես առաջ չկա։ Առաջ եկավ այդ դրված հանքերի խնդիրը, հետո արդեն անհնարին է դառնում իրային։
Սկզբից կանխարգել։
And that's where the pressure comes from the government saying, well, we've got to get this done because we've got to get the investment happening. So that's the counter to the argument that you just ran, running here, that is countered by the pressure of a developing economy wanting to get the mine up and running as quickly as possible. You see? And that puts pressure then down the track on the it creates legacies because there's been pushed too fast here. Now, when I say too fast, I don't think that, I think I said the other day, it's 7 to 8 years for your average mining project to get from first exploration results to production. At least. Oh, to license, sorry. And then it's 10 years to production, on average. So, just taking a bit more time up front is actually not that big a deal.
Ընդհանրապես տիպիկ հանքարդյունաբերության նախագիծը կարող է 7-ից 10 տարի տևի մինչև թույլտվություն ստանալ։ Այնա որ մի ամիս, 2 ամիս, 3 տարի միգուցե ավելի բանաները ժամանակ ներդնելը, որ ճիշտ պրոցեսը գնա, մեծ բան չի։
So there's 6 elements in a best practice jurisdiction for environmental management in the legal regime. Liability rests with the polluter, public involvement, separate enforcement, environmental enforcement from the mining regulation, issue approvals which can be taken away if they're not complied with, and massive fines for harm. Continuous monitoring is required and measured against accepted standards, and then there's judicial review by a court. These are the sort of legal issues that you need in any really good system.
Առաջինն է, որ բոլոր տեսակի պատասխանատվությունները պետք է կրի շահագործողը, հաղթողը, ուրեմն հանրությունը պետք է ներգրավված լինի, պետք է շարունակական մոնիտորինգ եւ վերահսկողություն իրականացվի։
Պատասխան մաչիության հասարակ։
Իսկ ուսուցիչը պետք է լինի այսինքն ոչ թե նույն մանից, որը տալիս է թույլտվություն, այլ ուրիշ մանից։
Անկախ վերահսկողությունը։
Բանը։
Which one is
In your
Երրորդը։ Այսինքն իսկ ուսուցիչը պետք է լինի այլ մանից, ոչ թե նույն մանից, որը թույլտվություն է, որպեսզի շահի բախում չի լինի։
Շահի բախում, այո։
Շուրոթը
Այո, շարունակական մոնիտորինգը ինչպես հատեցինք։
Չէ, շուրոթը ասել պետք է եթե թույլտվություն տալիս է, պետք է իրավական հիմք լինի, թույլտվությունը չհայտարարել, եթե կապ լինի եւ նաեւ հսկանական դուքանքներ լինեն, եթե արտոթեց շրջակա։ Ինքիրոց այդ մշտական դիտարկում։
Եվ եթե արտադրության մաչելիության մասին
հետաքրքիր եւ այսինքն եւ անհատներ եւ բկներ իրավունք ունենան բանական
Բացը բաղադրիչներն են լավագույն փորձ ունեցող երկրներում։ This is one thing he wants to put on Facebook.
Can you share the presentation?
Yeah, it's all independent. They're rural universities.
And yesterday's as well.
Yeah, here it's true that sometimes NGOs apply to the court and they're told you don't have standing to start a case because you're not directly affected.
The warrior.
For someone from practical field. And we have a court decision, a constitutional court decision on this access to justice related to environmental issues by NGOs. And
problem is that even that court decision didn't spread any light into this issue. It was interpreted differently by first instance courts. Arthur.
Սահմանադրական դատարանի վճիռը, որ առաջին արձանի դատարանները էլի հարցավաբար են մեկնաբանում, էլի։
It's under a box if we speak about this issue. It's very it can be a topic for
full day.
Yeah, huge research.
You have the problem that we've been identifying in terms of gaps is you essentially have this structure. You actually do have it. You just don't have the detail that best practice jurisdictions have. And so no one really knows how these things are going to play out in Armenia because we don't know what the sub-rules are.
Well, I'm not sure we have all the components. I'm not sure the sixth component in this is in place, right?
Exactly.
CSOs don't have a standing in court.
Legally, I mean, if we speak about the legislation, no, but practically we can. Now we have 3 pending cases in the court, and soon there will be a 4th one.
They have already accepted cases from NGOs. We have this precedent because of this constitutional court decision, which says that they can, but it is interpreted differently. It still leaves room for discretionary approach by a person.
But the government can legislate for it to be allowed. It's not hard.
They had the opportunity to do it, but they didn't.
Now,
the IA law.
Now the law on NGOs are in Parliament. They passed second hearing, and there is there's an article. There is a provision there which allows NGOs to apply to the court for certain in the framework of certain conditions to litigate the environmental permits. So, yeah.
Now the second dot point about public involvement, I didn't put it in here because it's not present in every jurisdiction, but we have public rights of objection. So if you're a landholder or you believe that you're going to be adversely affected by an environmental impact, you can object and take that objection to court as a third party. But there are other jurisdictions that don't have that.
But does that relate somehow to the access to land issues?
Yes. Yeah. Well, yes, because it's often the landowner has automatic standing to bring these objections, you know, under the statute, under the law.
So the only reason, or one of the reasons that landowners refuse to give away their property for these projects, maybe that objection to the court?
Well, they'll largely a landowner just wants more compensation, and so they use the objection as a way of levering more out of money.
The second point in our case is, I guess, the only one which is more or less normally regulated in legislation in detail. But there is a law and there is a governmental decree which speaks about details of organizing and responsibilities of these public hearings, etc. But the issue is that the communities are not ready. For instance, several days ago, I was in Kajaran, and it's a huge mine, the biggest mine in Armenia, almost 90% of the whole turnover in mining industry. I guess before Tevut started.
Royalties,
yes.
And 90% of royalties.
Yeah, it came from Kajaran. It's huge mine, and they brought the project for enlargement of the mine site, but they don't have enough space for pouring their wastes. I mean, telling them is not so big to enlarge the project. But from the communities, there were only two persons. One is from Kapan and one is me. From civil society, participating in that. Plus, there were majors of surrounding villages, representatives of the company, and the media, journalists. That's all. Just two persons from civil society. Nobody is.
It's very hard to absorb the complex issues that are involved, right? The community members. And then they come there and they're bullied and they're threatened and they're kind of not treated well. They're treated like idiots, and it's just like, why would anyone expose themselves?
The protocols of the community here is falsified.
Yeah.
You have a great debate, and then the mayor signed the protocol at the end saying that everybody agreed with the proposal, it was fine.
Yeah.
We have also lack of awareness or information. I mean, the legislation does give them the power to the community the power to really object. And we have cases in Zahka, when the overall community and mayor objected and no money in their communities.
But if the mayor is on the mining
doesn't matter if that's what I'm saying. If the community members are against, that doesn't matter if the mayor is for or against. If they are empowered enough to stand for their rights, they know about their rights.
There was one near Aparan. There was a case near Aparan. Yes, Tuchman, where they said that the protocol had been falsified. And the mayor was on the side of the mining company.
We use the word massaged.
So whose side are you on?
Massage?
Well, he actually is on both sides.
On both sides.
That's where
He makes his.
He's where the money.
I'm again for hire.
He's a good liar.
Ճիշտ ասած մի երբ բառով ասեմ, ֆինանսային խոսում են 6 կետերի մասին խոսում։ Մի քիչ ոնց որ յուրաքանչյուրի մասին Հայաստանի կոնտեքստում արկահայտներից խոսացինք, արտադրության մատչելիության տեսանկյունից, որ ՀԿ-ները, որոնք ուղղակիորեն չեն ներկայացնում այդ համայնքներում կամ այդ տարածքներում չեն այդ շահառուներին ուղղակիորեն չեն ներկայացնում, դա դառնում խնդիրներ ունեն ներկայացնելու բայց մեզ մոտ այդ բացը կա, մյուսն համայնքներում որոշումների կայացման այս ընդերքօգտագործման դրույթների հետ կապված խնդիրներ կան այն առումով, որ համայնքապետերը շատ հաճախ իրենք են որոշում կայացնում համայնքի փոխարեն տարբեր պատճառներով եւ որ համայնքի անդամները քիչ են տեղեկացված իրենց իրավունքների մասին, որ կարող են բարձրաձայնել եւ իրավ իրենց իրավունքների տերը լինել, որովհետեւ օրենսդրությունը դա թույլ է տալիս։ Պարզապես այնքան այդ փուլ համայնքներում այնքան քիչ են տեղեկացված իրենց իրավունքների մասին, շահերի կամ ինչ հետևանքներ ունենալու հանքարդյունաբերությունը, դրանով պայմանավորված որոշումները միշտ չի որ ճիշտ են կայացվում։
Եվ նաև ինչքան են իրազեկված լինեն իրենց իրավունքների մասին, ընդդերի սոցիալական հարաբերություններ են, կապերը իրավկավոճը չի ուժ ունեն։ Իրենք կարող ասեն հավաստանում են իրավունք ունեն, բայց ես հարաբերություն չեմ խզելու ես մարդու հետ, ես խնդրի վրա։
Բացի խզելու, թավուտում օրինակ բոլորը այդ հանքի անով կոպիտ ասած այո, սոցիալական դերը այնքան մեծ է համայնքներում, իրանք այդ խուլ համայնքներում այնքան քիչ է եկամուտի այդ հանքարդյունաբերության ընկերության կողմից տրվող չափերի համեմատությամբ, իրենք շատ ժամանակ ուղղակի փոլ են գնում այդ սոցիալական խնդիրների
Մողոքները մենակ գնում էին նրա համար, որ իրենց փողերը վերցրել են ու քիչ փող են տվել։
Այո, մենք հիմնականում եվրոպական դրան կոմպենսացիա
I think the discussion is going around. Often the communities, even if they understand their rights, sometimes they, for a couple of reasons, they may not want to exercise their rights. The relationships they have with the people and the community. It is a very, not a rule-based country, it's a very relationship-based country. So often people don't go to the path of conflict. And the second issue is that for them, it's often the grievances where I didn't get enough out of this. And there's a few cases now in the European Court of Human Rights where the landowners are taking the company to the court saying this was inadequate compensation. Okay, go on.
So, in best practice jurisdictions, there is this thing called a social license. It is a thing that is once again, it's the community's weapon to keep the miner from causing the sorts of legacy problems that arise if they're not accountable to the community. And this is an accountability mechanism for the community. The community can, a social license is essentially an absence of protest and a reasonable level of support for the project by, relevant sectors of the community. I'm not talking necessarily about NGOs now, but I'm talking about, the local community supports the project, they're getting jobs out of it, there's compensation paid to landowners, various stakeholders are supporting the project where they might not have in the past. So, and it's not an official thing. It's just a way miners say, have I got my social license? Am I acting in a way that is not inconsistent with the community's objectives, planning objectives, social and environmental objectives?
And this social license agreement is a document?
It's nothing. It's just what they do. They refer to it as a way of saying we're doing okay because there's this absence of opposition.
Since սոցիալական թույլտվություն ինքնասկիչի ֆորմալացական ինքնի կառավարի որ եթե չկա ինքնություն եւ եթե կա բավականաչափ համաձայնություն ինքնության կանոնին եւ համանուն որ քիչ շատ կա համաձայնություն սոցիալական թույլտվություն է ստացել ինքնություն շահառուները.
So there's a project in Australia called the Adani coal mine, which is in Queensland. It's going to be I think the biggest coal mine in the world when it's commissioned, which is shortly. There's been 3 federal court cases from NGOs and traditional owners trying to stop it. So that's happening in the court. They're using those judicial review processes. And then at the same time, there are full-page ads being taken out by Central Queensland community saying we need this mine because we've been in massive downturn and we need the jobs back because our communities are hurting. So the mine's got government support, it's got local community support, it hasn't got NGO or traditional owner support. So it's a kind of, do they have their social license? Hard to say. Because there's a measure of protest, but when you go to a protest against this project, there's like 9 people there, and they get a lot of media attention, and they get a lot of social media attention. But whether the company's lost its social license, I suspect they would say that they hadn't, because the community's taking out full-page newspaper ads saying, "Get this done. We need it approved. We need to have the project start."
Եթե լինի աշխարհում ամենամեծը եւ մի կողմից համայնքը ընդհանրապես համայնքը կողմա, կառուցում կողմա, բայց ՀԿ-ները եւ բնիկ ժողովրդի ներկայացուցիչները դեմ են եւ կամ բան երկաթական գործ ընթացքում մյուս կողմից համայնքը թեթերու հոդվածներ ռեկլամանում որ մեզ պետք է աշխատատեղակեր թող գնա առաջ չբողոքենք մենք համաձայնենք. I think շատ քննած հարուցա ունես սոցիալական բանտուլուսն չէ։ Ինքնին ասում ունեն, ասում համայնքը մեր հետո ուղղակի հատուկ է մացիկ մանեն, մի քանի ծրագրեր դեն։
Իդեալ պատմություն։
Ով իր կարգները բավարարում է դրանով համաձայնով չէ։
So this is part of the politics of best practice jurisdictions now. Does the mine have its social license or not? And I think what the CSOs in Armenia have been saying is that no big mining company's really got a social license at the moment. There's no trust about mining.
It's not because of the lack of trust. I assume towards mining companies. That's the lack of trust of overall governmental system.
Governance of the
I meant the whole thing. Yeah.
Yes.
No, that's what I meant.
And plus,
Very narrow sectors.
governmental officials are too much involved in that sector, and that's all these issues bring to the total.
Խոսքը մարտարփան իրախոսքն էր որ հիմա զարգացած երկրներում լավագույն փորձ կիրառող երկրներում այս սոցիալական թույլտվությունը ունենալը հիմնական է քաղաքական process-ի երկխոսության հիմնախնդիրներից մեկն է։ Արդյոք ունի հանքարդյունաբերության սոցիալական թույլտվություն թե ոչ։ Այդ ձևով ձևակերպվում է քաղաքական դեպքերում։ Եվ Հայաստանում իրակարծիքով իր եզրակացություն ունենա, որ հիմնականում որևէ հանքարդյունաբերող չունի այդ սոցիալական թույլտվությունը, Արթուրը լրիվ չհամաձայնվելով ասեց ավելի շուտ ոչ թե հանքարդյունաբերողի դեմ թերհավատությունը, բայց ավելի շուտ ընդհանրապես համակարգի պատշաճ աշխատելու վերաբերյալ թերհավատությունը։
So, just to talk a bit about abandoned mines in particular. One of the things I don't really understand, and it's actually it happened last month in Queensland, is the government going after the people who caused the damage, like by suing them for taking the money. Sorry? Hasn't tended to. So there's a uranium mine that hasn't produced uranium for 30 years up in North Queensland, and it started to leach uranium oxide or whatever the uranium sulfide, something really unattractive.
Doesn't anyone live in Queensland? Coal, gas, uranium?
Yeah, we're that kind of country. We're a big mine.
But by the way, I just checked. Queensland is 1,900,000 square kilometers. Armenia is 29,000 square kilometers. I mean, we're that zone.
We have sheep stations the size of this country.
Լքված հանքերի մասին է խոսքը գնում եւ դրանց հետ կապված ամենամեծ խնդիրներից մեկը որ պետությունը չի հետևողական լինում պատշաճ կերպով դատական կամ այլ միջոցներով լքված հանքերի տերերին պատասխանատվության ենթարկելու Queensland-ի մասին է խոսում օրինակներով որտեղ Ուրանի հանքավայրերից մեկը 30 տարի չի շահագործում եւ այժմ սարսափելի բնաբանական խնդիրների առաջ են կանգնած արտահոսքի եւ պատճառներով եւ կանոններ ու պարզապես համադական է տարածքների առումով Queensland-ը մեկ
միլիոնին արոզա կառավարության
We call it norm, naturally occurring radioactive material.
Ուրանի բանի մասին բնական տեղի ունեցած ռադիոակտիվ
So that mine, the government's gone after them under these new laws that I've been talking about.
Մշակել, որ կառավարությունը գնում է այն հանքարդյունաբերող, որ 30 տարի չի աշխատել, գնում է իր այդտեղից որ
Come and pay and clean this up. It's a mess.
Does that retroactive legal force, does it have anything to do with retroactive legal force?
No, because the damage is happening now. So they're basically saying it's your responsibility, you've got to go clean it up.
The damage is happening now.
Well, the waste rock dump is leaching uranium. That's what Aboriginal people call poisoned ground.
If you were there, Laura, would you say trapped you or creating a responsibility for the
They did try that. The lawyers did try that, but the government said, do you still own this tenement? Yes. We haven't surrendered it back to you. Sorry, you haven't surrendered it back to us.
Yeah.
So you go fix it up. It's your problem.
That's the political will.
That's all. That's what that's going to do. People are going to start. How do they disown properties?
Well, there's one very clear way to do it under Australian law, and that is to go into liquidation, and then a liquidator can disclaim the assets, and that's what happens. That's exactly what it is.
As paragam as օրենք որ սկսեն հետապնդել մեծ ռիսկ է որ իրավական անձերը կամ ով որ դերն այդ տարածքի սկսելու է ինքը բանկրոտ լինելու իրավաբանը սնկացնելու է եւ իր վրայից վերցնի տարածքները. And the state is going to get huge assets.
What they've done with the what they've done with these new environmental laws is they've gone after anyone who benefits. Directors, significant investors, significant shareholders, anyone who directly benefits. Now the reason these guys haven't given up their mining lease is because they're waiting for the uranium market to bounce back after Fukushima.
30 years.
Because it's a different company that originally did the first mining. This new guys have bought this mine to produce, there's more uranium there. They want to produce more, but they're waiting for the price to go up because of what happened in Japan. So strengthening enforcement options, that's a very general statement, but what I'm trying to say there is that the government gives itself more power to go in and inspect and enforce. Now, I have a question. When a mines inspector goes to Kajaran, sorry, what do they think is going on when the tailings are directed straight into the river? Like I'm kind of going, doesn't that kind of ring an alarm bell with somebody?
The tailing doesn't, in Kajaran, the tailing doesn't straight go into the river. The water, untreated, unfiltered, goes into there. In Agarak, the tailings go straight into the river.
Okay, use that as an example. That's fine. Sorry to besmirch Kajaran, but what do they think? Do they not understand that that's incredibly dangerous?
They do.
It's a corruption issue.
Well, it's either a corruption issue, yeah, at some level it's a corruption issue, but I think it's sometimes, like we were told yesterday, point blank by the health ministry people, we were asked there's a 2-3 year moratorium on any environmental health inspections, period.
The government ordered that, did they?
Yeah, let them do business.
But it doesn't relate to the emergency situations. In Kajaran, for instance, there was emergency situation when
after 5 years, you know, same thing, it stops being an emergency, it becomes operating.
A national crisis.
Right.
During a month, this stream flows from Bացման to Kajaran. Բաշնյանն ինչ որ բան արել, ընդհանրապես տակիցացնում դուրս է գալիս։
Okay, guys.
Ոնց չէ, բայց այդ բաշնյայի բան բարձվածքն է գալիս, սա տակիցացնում։
Բաշնյայի բարձվածք չէ։ Հենց փոչատարն է մտարվել ավտոբանի վրա, որաշենքի վրա։ Փոչատարն է։ Ոչ թե մտարվել է, այնտեղ ստերան է բացում։ Չէ բացում չկասնի։
Եկեք ծանոթ նշանակենք։
The fines here are not consistent with best practice. The fines have to be a disincentive. They have to be something that hurts. And there's no point in fining a miner like $10,000 US. They'd pay that. They'd go out for a meal for that. It's just not enough money.
Yeah.
And so the fines need to be. I mean, the fines in Queensland are. For an individual director, they're $750,000. Now, these guys, some of them are wealthy, but they don't have a lazy 750 sitting around waiting to get used. So,
is there a responsibility on the company to rehabilitate the area, to restore the area?
There is the power to do that. There was the power before they brought in the new laws so they could force a clean-up.
And that means that the situation got worse?
No, so before they brought in these new laws I've been talking about, the department could order a clean-up by a miner and make them pay for it.
Yeah.
So that's been there for some time, that power. That's the sort of strengthening enforcement option issue that I'm trying to suggest. There's a range of things you could do to ensure that the government could force them to comply.
Okay.
And clean up as
well. What about
well.
after the new law?
Sorry?
What about after the new law you're talking about?
After the new law, well, that's just given them the power to go after people who aren't directly responsible for it, who are in a group of people who, you know, in a group of companies. Any of the other companies in the group can be told to pay for it, and any of the directors of those companies can be told to pay for it. So they're trying to, you know, cast the net very widely of all the people who would be liable to pay for the damage. So it's very broad.
Their responsibility is taken away from the company who's polluting.
Well, the company sometimes runs out of money, so they can go after the directors instead, as personally liable then.
Oh yeah, that's an interesting approach.
And you don't have that here.
When you say force
You
a
do
company,
for safety, but not for environment.
when you say force a company to clean up, if the company says I refuse,
Well, the government can go in and clean it up and then hit them with the bill.
if the company then decides to go bankrupt.
And then they brought in these new laws where they can go for another company in the group, or they can go for the directors of that company, or they can go from go for any significant
Well,
investment.
your parent company is offshore.
Yeah, they can find individuals who are
You could
leading
then-
these
you
companies,
could
and
then
they can
enforce
sue.
a court order in Bahamas or I don't know, British Virgin Islands or something.
Well,
like that.
no,
To do that?
no, you can go for there has to be an Australian resident director of these companies, right? Even if
And
there's
that's
an option.
in the case of Armenia, you had something. to do
Well,
with-
this is why you'd have to bring in, that's why I've been talking about the depth of the laws. You have to bring in there's a whole raft of provisions you need to bring in to fill all these loopholes. All you're describing is a set of loopholes, and they can be plugged. And this legislation does plug it.
Interesting.
Servant albedke, տնօրեն դինի Հայաստանցի։
Sure.
It's
Ավստրալիա, բանը, ստիպում որ տնօրենը պետք է լինի ավստրալիացի։ Այսինքն կոնկրետ ունես անվազ մեկ ֆիզիկական անձ, ու նկատմամբ կնորս մի բան անես։
going down getting your own, or
Թե չէ բանը նայգյուսն կարող օֆշոր լինի, կրացվածում իսը որտեղ։
Մենակ դու չես ասել,
So,
I need to go.
yes, and we want to do a small break with Josh and Ջոնաթան. Կվերադառնանք 10-20 կես կամ
Break.
40 րոպեից, հա?
right?
Yes. Շարունակենք մնացած թեմաները։
I hope I'll be able to come back for the session on beneficial ownership. I'm not sure what it's called. The guest be around 2:30ish. Because unfortunately, she's very ill.
one of the civil code enable the state to contract and enter into legal relationships with citizens and legal persons. That means that the mining contract is just a contract for the purposes of the civil code like any other contract. Okay? So the mining contract is governed by the terms of the mining code, chapter 18 of the civil code, which is the obligations chapter, section 450 particularly. And the mining right granted under the mining code will be invalid if it's not registered by the state. That's the civil code provision relevant there.
Australia.
All right. No, this is your code.
Section 450.
No, that's not the mining act. The mining code. This is the civil code.
Oh yeah.
Your civil code. Right.
Oh yeah.
Okay. So you can't, once you've entered into a contract, you can't unilaterally refuse to perform an obligation. That's part of the law. So if they sign these things, now we had a discussion with the mines department, or whatever it's called now, the infrastructure, energy infrastructure department. And we asked them directly, how did they see that contract? Did they see it was it a commercial contract, or was it? And their answer was, they said that it set out the roles and responsibilities of the state and the miner, but it wasn't the sort of thing that they would enforce. Is that the
Not
reason?
enforced, but in case of breaching
Environmental rules.
environmental rules, contract does not serve as a tool to call for remedies and compensation. They call remedies and compensations according to legislation, not according to.
Totally. That's why now we are thinking about review of the system of contracting, because it's a package. I mean, the mining permits consist of a package where there is a license, there is an environmental permit, there is a contract, and land allocation act. There's 4 documents. So we say, why do we need so much documents? There can be only one document, which can be treated as administrative act, let's say license, where the whole information will be put, and it will not be a contract to contract, and therefore it cannot be like confidential. So everything will be in one paper. The issue is transparency, but how it is formulated legally, it's just a way of, issue of mechanism.
Yeah, so I guess I actually see the existing contracts with each of the existing mines as enforceable commercial arrangements under the Civil Code, such that the state could, if it wished, seek damages for even some of the existing damage, some of the environmental damage that's occurred. So Kajaran, case in point, pretty ugly, unattractive tailings situation there. There's a mining contract with them. The mining contract says you must abide by all of the laws and norms of Armenia. Well, one of those norms is that you don't pollute. Now, the mine waste provisions says that the mine is liable for these things. And the government representative yesterday said that very clearly, didn't he? Said the mine is liable. But they're not enforcing it. So why not use the contract to do that? Now governments have, miners know that governments can take their permit away. So there's this little dance that's done between miners and governments, where the governments put subtle pressure and the miner backs off. Right? And then when the government looks a bit weak, the miner comes in and says, give me a royalty holiday, and there's another dance around that. Right? What you could do with this contract is you can say, why shouldn't we sue you for damages for all of the damage you're causing to the environment at your mine site? Why shouldn't we? Here's this provision in the contract. It says that you had to abide by those laws and you didn't.
Yeah, but when saying we understand the government or civil society or other groups?
Well, the civil society is not a party to the contract, so it can't exercise its rights under it. But the government can.
But they don't.
No, but if they, the strong message I got yesterday was the government's not opposed to doing things that will create a more responsible sector. I got that very strong message. I don't know, they might water things down, they might not do as much as you would like them to do, or perhaps I would like them to do, but they're still going to do something. So this is an opportunity for them with the existing mines to go, well, let's just test this out a bit. Let's just test the boundaries of this a bit and see if we can get the miner to clean up. They've made a lot of money, that mine that starts with Z. That's Kajaran, isn't it? Yeah, so the Kajaran mine has made a lot of money. But they've left a mess.
The one thing you mentioned, I remember, is that through contract, the state can ask for even more remedies and more compensation for violations rather than through legislation. That's why the contract is right.
Yeah, exactly.
It's as a commercial contract, you can really ask for compensation through contract. The compensation might be higher than if you did some violation of environmental legislation, which are ridiculously low rates for violations.
I see, but my concern is about the involvement of civic sector in these procedures.
I'll come to that.
Yeah, all right. Because it's in Armenian case, it's a little.
No, it's good. It's a very good point. I'm coming to it.
But it's interesting. Yes. Okay. You'll come to it.
Yeah, I'll talk about it. So it's enforceable by the state against the miner. The state could have a security provision in the contract which allowed the state to get a mortgage over property held by the company, such that if the company breached the agreement, the default provisions would cut in. I mean, if you drafted a proper commercial contract, it's not a proper commercial contract at the moment. But if you drafted it like that, you could exercise the rights of the mortgage and sell the property to get the money back, right? These are the sorts of things that you do when you're lending money to people. You get a security interest over the property, and you can do all of that under the civil code. It's all be clear. So, in best practice jurisdictions now, there are almost no contracts between the state and the miner. There used to be in Queensland and Western Australia in the 70s, the 60s and 70s, a long time ago now, and some in the 80s. And they were contracts between the state and the company that were given the force of law by the parliament. So they were kind of really, really strong contracts, okay? But they were all really to protect the miner, to give the miner comfort that the state wasn't going to change the rules on them.
Yeah.
Right? That was really the point of it. And the big miners all asked for these agreements to make sure the state can change the law on them and charge them more royalty, for instance. Or whatever it might be. This contract is not like that, and the long-term strategy should be not to have a contract, because the state has the legislation, and if the legislation is fully detailed, as we've been talking about, and has all of the provisions that you would ordinarily want in legislation, and all of the depth that you want in the laws, you don't need a contract. The problem at the moment is they're not using the law to enforce provisions of the law, or to enforce if there's damage, and more, the fines, even if they did enforce using the legislation, are so weak that they wouldn't be a disincentive to stop the activity and stop the damage. But under a contract, if the state suffers loss, which it would do because the company's not cleaning it up and it's a legacy mess, the state will eventually have to find some money to clean it up. That's the state's loss, and that is compensable under the civil code. They can claim damages for it in a way that they could never recoup under the current fine arrangements in the mining code and the environmental legislation. So I think that for an interim period, say between now and when the laws are more detailed and the sub-regulations are written and those kinds of things, the contract can fill in the gaps of enforcement. It can actually be used, if they draft it really well, it can be used to keep miners on the straight and narrow. Where civil society can't do it yet because it's not capacity built enough, where communities are certainly not able to fight it because they don't have enough resources to do it, and in circumstances where I actually think, given what I've seen about tailings dams here, it's not a matter of if one of these collapses in a seismic event, it's a matter of when. It's going to happen, and when that happens, we've seen that the cost of the cleanup in Brazil for that tailings dam that collapsed and wiped out that village was $25 million. Where can the state get that kind of money from if it's not from the miner? So the contract becomes, a really kind of fundamental document in those circumstances where there's been massive damage.
Yeah, I agree.
So it's a kind of a guarantee tool, not only for the company, so as the state doesn't change the rule of the game, but also for the state itself to guarantee for any kind of damage.
Exactly.
But what we do, we don't use it as a tool for
in fact, it's not really clear what it's for.
You mean contract?
Yeah,
the
contract
contract
plays no role in our system.
Yes, but still legislation in a declarative level, in a higher level, it derived from the legislation. It derives that the company has to do, but still there is a point that there is no financial guarantee. If a company cannot do it, it can be bankrupted, and that's it. So
But if the government's not going to enforce the contract, they might as well write the company a letter and say, our role here is this, and our responsibility is this, and your role and your responsibility is this. There's no point in having a contract because it's not doing anything.
Yeah.
What's it doing? What's it contracting? A contract is the idea, to me, the fundamental idea of a contract is that there are obligations on both sides, and if you don't perform those obligations, you get to sue for breach.
But I think that in the contract there should be clearly defined the financial guarantees in line with the potential emergency situation. I mean, if it is a metal mine, we're telling them the financial guarantee shall be equal to the possible emergency situations. Or
I agree, and in fact, I'll say so in a minute. But the state has to be prepared to monitor and audit compliance, exercise these security interests if they're drafted into the contract, and be prepared to cancel the miner's right. There has to be some consequence for bad behaviour. There always has to be. The risks, though, if they did any of those things, the mine's large, generates a high royalty income, the miner just threatens the state and says, we'll pull our investment and go somewhere else. And then there's no royalty income. And that's where that Kajaran mine's got the government over a barrel, because it's contributing 60% of the royalties.
In a few years, it was the first tax payer.
now it's 17. Right now it's 17 because of the collapse of the crisis.
So that sort of makes the government pause before it takes action against them, because they're going, there could be a backlash here. But on the other hand, the damage that's been caused down there is pretty serious. They also risk political backlash if the communities. So the opposite thing is that if they don't take the action, community beats them up because they're not dealing with it. And well, there's the obvious thing: if they don't take any action, there will still continue to be adverse impacts. So the contract as it is now gives the authorised body the right, but not the obligation, to require the mining operator to operate the mine according to accepted norms and rules of use and maintenance. So it doesn't have to. But one would have thought that it ought to be obliged on behalf of the people of Armenia to ensure those standards are met. The other problem is, what standards? What are the... that provision in our law would be void for uncertainty, because we don't know what the accepted standards are. There aren't any. That's exactly what we've been talking about all the last 2 days. Is there are no accepted standards. So that contractual provision cannot operate. There's nothing for it to operate on.
Exactly.
So if we don't know what the norms are, and you can't fix them, you can't apply that provision.
You need to refer them from the contract in the contract, because there definitely, I mean, I don't say there are all the standards and rules, but there definitely are certain standards and rules.
There are certainly Soviet ones that are being abided with, they're sort of part of the accepted standards, as I understand it.
Yeah.
That's what the government was saying yesterday.
And do they need to be referred?
Absolutely, that's what, this needs to be fleshed out and made much longer. It needs to set the standards.
It means that the contract should be amended every now and then, because the standards and norms are being amended.
That too, but you can amend the template anytime you want.
And two things should be reflected in there. First is the conditions of permit, because permits are given with the conditions, and the contract should reflect these conditions. And second one, when we're speaking about the obligation of government, not the right, obligation to government to require the...
I'll just send you the slides again.
Yes, especially yesterday's files, I need them.
You're welcome to have them.
I mean, the obligation is actually in the contract currently, obligations are towards the opposite party, the company. But this sort of obligation is before the society, civil society, obligation to ask the company or to demand from the company to compensate, to recover, etc.
Provides exclusivity for the miner to conduct geological research. Arguably in clause 2 it doesn't give the miner exclusive rights to mine, which is bizarre, because I don't know, I wouldn't take a mining right if I wasn't the exclusive miner. I mean, there's no point in having multiple miners coming into the same allocation. It's crazy. The state can direct the mining operator if it sees fit to do so. Those are the clauses there, but doesn't ever do it.
This exclusiveness is what exclusivity are we talking about?
So exclusivity is that you're the only miner allowed to conduct the geological research. No one else is allowed to get a permit to do it.
It's when there's a provision in legislation when if one made the geological survey.
Yes, but this is not about extraction. This is geological survey.
Yeah, but if I got the correct point, you are speaking about a company which did the geological survey. It has privileges to take
Extraction.
Yeah.
It's a geological research and extraction.
Yeah, so there's a clause that says, I think it's clause 2.1, that says the state will grant a mining right to the miner to conduct mining operations, or words to that effect. It doesn't say it's exclusive. So the state arguably could go and grant another mining right for the same area to someone else, which no miner I know would sign up to a contract that didn't give them exclusive mining right. Otherwise, how can you guarantee your return?
Oh, you need to mention this exclusivity in the contract.
Central.
It's made hard to do more to control capture. Mining coding and capture. So as my partner manage, company doesn't give it all. Now the contract, իրավական contract. Now how is it exclusivity պայմանագրում նշված չի.
Let me give you an example. Say you rented a house from me, and then I rented it to somebody else as well. Would you want to live there?
I'm signing a contract with you on renting an apartment.
Yeah, and then I sign the same
If
contract.
you don't mention that I'm exclusively
Yeah,
renting
then
the
I can rent it to Arthur as well.
I see. Okay.
You see?
In the practice, I don't know this kind of situations, but legally,
But
I mean,
mining,
formally,
you absolutely have to be the only miner. So my partner, Martin Clapper, who is a resources guy as well, he has been for the last year and a half fighting the Solomon Islands government because our client was granted an aluminium or bauxite mining lease on one of the Solomon Islands, and then the government got a large pile of cash from a Chinese company or Indonesian company who came in, and so they granted another mining license over the top of our client's mining license. And they started shipping bauxite because they paid the government heaps of cash. So that drafting, leaving out exclusivity in relation to the grant of a mining lease, may be precisely the reason. It may be that the government's going, well, you know, if these guys don't pay up, we'll give it to someone else to pay up. Do you know what I mean?
In our situation, there is a similar associated situation when the main geological ore, let's say, the main substance, is divided into several parts and given to different companies. But it's actually the same. They're very interrelated. For instance, in Sunni, there is Tashtun, Lichk, Aygedzor, Vartani, Verim, Vartanizor. Everything is in a small area, and they are very interconnected. But they give it the license of the survey and exploitation for different companies. It's something associated with this situation, but not completely that first.
There's no real detailed stipulations as to what the miner has to do. So the miner's not given too many obligations. Under 3.4.3, the mining operator must meet the requirements, again, of the rules, norms and standards accepted in the Republic of Armenia. Well, what are they? It doesn't say what they are. We're just supposed to guess.
Dig into the legislation to understand what it is.
Well, but, you know, it says they're accepted. By whom? Who? I reckon if I walked down the street and knocked on the door of one of the mining companies and said, okay, what are the accepted norms for your activities on the mining lease, they wouldn't be able to tell you.
Yes.
And it's caused huge corruption risks. So to go and inspect, say, you know, there is a provision in there.
Too much ambiguity and too much vagueness,
Yeah.
both in legislation and, of course, in contracts. And
I think it's probably interrelated in a way. If the legislation is vague, the contract is
will be vague as well.
from legislation.
Yeah. So 3.4.11 says that mining operator must ensure the preservation of the subsoil, atmosphere, soil, forest, waters and nature and other environmental objects. Well, Kajiran, if that contract's enforceable, Kajiran has breached that provision. Prima facie breached that provision. Because they haven't ensured the preservation of said subsoil. Undek.
And who should go there and dig it?
Is that the word?
What?
Undek? Undek. It's my first piece of Undek. Undek. It's the only word I'm going to take back.
It's a Armenian way of spelling, because we have these letters g, g, k, d, d, t, z, 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 different. And dek is with k. Dek.
Our premier, our chief minister of Queensland is a woman called Anastasia Palaszczuk, but her name is spelt P-A-L-A-C-Z-S-Z, right? Because I think it's Polish. Polish. But the only reason I know how to spell it is because someone explained that the best way to spell it is P-A-L-A, Canberra Zoo, Sydney Zoo. And then you remember which order the C and the Z and the S Z go into. So 3.4.18, the mining operator must ensure the implementation of the social and economic mitigation measures. That's enforceable. If it's not enforceable, what's the point of it? That actually says they have to do this. What they've said in their social impact assessment and their mitigation measures for the mine, they have to do. But it doesn't say how. What happens if the miner doesn't do it? What's the state's loss? Well, the state's loss is the social loss and the environmental loss. That's the loss. And what we're saying is that, take Kajiran as an example, the damage that's been caused is visible. You can see it. The cost of cleaning that up is probably in the hundreds of millions of dollars. I would have thought if you really wanted to have a crack under this contract, you could have a go at them for that money. Because I'm assuming the directors signed that contract without even reading it, because basically you're given it. And then, from what we gathered from one of the stakeholders, one of the mining companies, there's no negotiation with the terms of the contract.
Yeah.
It's just drafted, and I think he said they negotiated the size of the lease, the allocation area.
Yes, about the land. I mean, they wanted to be the one, but.
And that was the only negotiation they really had. Oh, and the financial guarantee, they decided what the number was.
There's a generic contract that just fill in the information from permit and other.
But it needs a fundamental rewrite if they really want to use it as an enforcement tool. I say if they do. Yeah. So there's a reporting requirement under the contract. I wonder if the miners actually do report.
They are required to report.
Do you have freedom of information laws here?
Freedom of information?
Information laws, you know, where
yes.
Yes. So I would, if I was in an NGO, I'd be doing FOI applications for all these mines to find out what they're reporting.
The law says the information, the access to information is restricted if there is a commercial secrets in it. And whatever they have, they think it's a commercial secret.
Yeah, it's a commercial secret that we're
at some point
dumping undiluted tailings into a river.
Commercial secret, of course.
Even if it's not commercial secret, they refer to some points and go on to court prove that it's not a commercial secret. If they don't want to.
So you're going to have a fight, but this obviously all of this fighting requires money because you have to keep going to court. So I just think the state can enforce this. What could third parties do? This is where CSOs come into play. What remedies do they have? Well, under Article 1058 of the Civil Code, you can bring actions for harm caused to people. I know you've got to sue for it, but you can do it, and you can do it for potential harm as well. So if you're is it Karpan that's near Kajiran? Yeah. If you're a citizen of Karpan, you could bring an action against the mine under these provisions for potential harm. 158, 1058, and 1059.
But you should prove it, you know.
No, sure, you've got to prove it.
Cannot.
Well, you
Because
can't.
company will say, go
Dude,
and
take some
it's not-
pictures.
It's not my harm, you know. Your health conditions got worse, or it's not my fault.
Good experts can provide.
It will
but
take
it will
so
take-
much money to organize.
Yeah.
The citizen of Kavan cannot.
You need an Aaron Brockovich.
Aaron Brockovich, but I was telling Arthur that Aaron Brockovich is now in Australia.
Yes, she's the public face of Shine Lawyers, who we describe as ambulance chasers. Do you know what I mean by an ambulance chaser? A lawyer who chases crash and bash accidents. So, public involvement. We talked about rights of objection this morning. You can draft objection rights for third parties into legislation. Now we've had, up to 2012, the Labor government in Queensland allowed rights of objection for third parties, people who are not farmers or directly affected, so standing for CSOs, for instance, they can object. Anyone can object, basically. Even if they live, 500 k's away, they can object if they think the project's bad for whatever public interest reason. Then the government changed and a more conservative government came in, and they took away the rights of objection for anyone but the narrowest of stakeholders, so directly impacted people, landowners, local communities, that kind of stuff. But no one else. You couldn't, if you were protesting a coal mine near the Great Barrier Reef and you were a greenie, you couldn't bring an action like you can, or like you could before. So they all got taken away, and then that government lost power only after 3 years, and so the Labor government came back in and restored all the full suite of objection rights. So if you can get objection rights into the legislation, you can certainly get more scrutiny of projects, because you can say, well, we don't like this aspect of the EIS, and then they just say, well, we don't care, we're going to go get it approved. You can then sue in the court. You can make submissions on the EIS. We've talked about how difficult that is, obviously, here. You could make submissions to the government on the ground of the mining right. And you can, in our jurisdiction, you can do judicial review. You can use street protest and social media. And look, I'm going to talk about Lock the Gate in the lecture tonight, but Lock the Gate is this organisation of farmers who protested against the LNG development. Now, could the civil or mining codes contain articles allowing third parties to sue for breach of the mining contract if the state does not? Well, you'd have to get the state to pass those laws, whether they would do that or not, but...
I'm very skeptical about this.
yeah, but I mean, these are possibilities.
Yeah.
In our law, there is a Section 55 of the Property Law Act says that ordinarily in a common law contract, only the parties who are party to it can sue each other. Someone from outside the contract can't enforce obligations under it. But what Section 55 of the Property Law Act does is it says, if you claim to be a beneficiary under that contract, you can sue one of the parties because you've got rights under the contract, right? Now, interestingly, that's in your code, right? So you've actually got, that's a common law concept, but Article 346 of the code says, another statute or agreement may provide an obligation may create rights for third persons with respect to one or both of the parties to an obligation. So the state could put into the mining contract an obligation to create third-party rights. And if I was in a CSO, I'd be hitting government up to do that.
But
and then you could sue.
But there is we had this sort of experience. There is a huge problem in our general legislation about this. As far as this is civic contract, court is allowed to put this. There is this sort of term, the measure to guarantee the claim. And what is the legal definition of it? That the party who is suing have to put in the court's deposit amount of money that after, if the court decides make opposite ruling, the damages caused to the other party shall be compensated from this debt. At some point, it's huge money. We have a situation not about the mining, but about the construction issue. There was a building, and citizens living around sued. Court started litigation and say, okay, put this amount of money, because if you say stop, if the constructor will stop the building up to the end of litigation,
sort of measuring the loss of the
it took money from bank, there are these costs, etc. So you have to put huge amount of money in there.
In our law, that's called security for costs.
That's, but it's not only this. I mean, it's a very complicated issue. This is the first part. There is a second part of it. There's Aarhus Convention. Armenia is part of the convention. The convention demands that the costs for this protection environment for the public, civil society, etc., shall not be overburdened. Shall be equal to the situation of, I mean,
economic context of the country. Yeah?
No, it is that the society, it cannot be put too much financial burden over the civil society groups who are litigating these potential.
That's criticism.
It's Aarhus Convention, but it's not reflected in our legislation.
It doesn't have to be, because the Civil Code says in the back that any international laws will be given. The court will have a problem.
Yes, but in case of Aarhus Convention, there's Article 3, which says that these provisions can be
displaced by other provisions.
Can be reflected, shall be reflected in the national legislation. If it's not reflected in there, so it's just it's obligation of the state to put it in the legislation.
If it doesn't, they still apply.
Yeah, but you know, in practically you cannot apply. You cannot go to the court and say, you know, there is Aarhus Convention. It says that.
But there's those provisions in the Civil Code that say that if there's international law on a point, you can refer to the treaty, and the court has to have regard to that.
But the code itself says that this obligation shall be reflected in the national legislation. If it doesn't reflect the national legislation, it doesn't have direct force. You know, there's an obligation for the state to reflect these provisions in the legislation. But the state can say, you know, I've put it these provisions, but I didn't did yet this much.
Does that mean that like the states have this discretion? Is it like discretionary? What's written in the article?
It's not discretionary. It's just you know, the way to avoid the responsibility, saying that you know, Aarhus Convention demands to incorporate into the national legislation this amount of provisions. So far, I did this one. I mean, this part, half of them. But the second half, I will do on the way, in a way. So in Aarhus the compliance committee of Aarhus Convention cannot oblige the state to do it faster. And current legislation puts this burden to the civil society, and we cannot claim in a civic way. That's why we are doing another way. We are we don't litigate the civic contracts in the civic. We don't start civic case. We start administrative case. We go to the administrative court. There is this sort of court saying that the state violated the legislation when giving these permits, and in this way, court cannot say put this amount. It's the obligation of the state. There is this nuance, this legal nuance in terms of Armenian legislation.
But that doesn't mean you couldn't get the state to put something in there that said that third parties can sue, does it?
We can do it, but we can afford ourselves to go to the civic court suing the company. We have to sue the government, saying that government, please do this way. And indeed,
I'm talking about suing the miner, not the government. I'm talking about suing the miner, not the government.
Yeah, but we cannot afford ourselves to sue the miner, because if we sue the miner, we have to put this amount of money in the court's deposit. We don't have this amount of money. But if we sue the government, the court doesn't demand to put this.
Yeah, but that doesn't really help you get the money back, does it? For the damage.
We will sue the government, asking them to do their obligation to get the money back. You know, that's this circle.
So they can sue, and they could put the money up.
They
Is that
can
your
sue,
point?
yeah. And we can sue the government saying that, look, sue them.
That's a long way, like,
Yeah.
But we don't have other situation is the amendment in the legislation that in terms of environmental cases, not to put on the society this burden to put the money in the court deposit. This can be a solution.
Anyway, so that's where I got to with the contract.
Yeah, it's you know, I didn't go into the details of the contract provisions, but it's quite necessary. I think it's a new idea.
that's a tool we don't use for some reason. Yeah.
But it's there's too much work to do, and that doesn't get into the contract provision.
Should we go to beneficial interests so we actually get it done? So a beneficial interest is where is a legal relationship in relation to property, where the legal owner of the property is separate from and accountable to the beneficial owner of the property. I think the way you use it here, and I've been trying to work this out, the way you use it here is that there is an indirect relationship between the person who benefits and the person who holds the property. So it might be an ultimate holding company, it might be an individual who's hiding behind someone else. You know, that's beneficial. They're the ones who are benefiting, but they're not transparently on the face of things. They're not involved directly. They don't appear to be involved directly. But in the common law, that is a very common form of legal relationship because it's, in some ways, for some purposes, it's designed to protect. So the beneficial owner of a trust might be children, and the parent is the legal owner of the property, but has to act and look after the interests of the children. Okay. It also. The situation where you have an ultimate holding company is not technically or strictly a beneficial interest. It's an indirect interest. So you use the indirect method of ownership through shares, where the company holds the interest, but the shareholder beneficially owns an interest in the company and holding a share in it. See what I mean? And you've got all these concepts in your code, and you also have limited liability for companies, which means that if the company goes bankrupt, they're only liable to the extent there's any money left, whereas for your citizens, if a citizen goes bankrupt, they have to be bankrupt for as long as it takes them to pay their dough back. So there's a slight distinction between the two, between individuals' treatment of bankruptcy and company treatment. Now, beneficial interests are for, they were designed to avoid tax. That's what they were for originally. So in the time of Henry VIII in England, he was taxing, and we have an expression, it's probably offensive here, he was taxing the bejesus out of people. That means he was really taxing them very hard. And he, people started to create these things called uses, which is where they would say, I actually own this property, but I'm going to give it to somebody else who's going to look after it for me. And then when the tax man comes along, I'm going to say, I don't own it. The legal owner owns it. So the legal owner would then say, well, I'll pay the tax, and this person doesn't pay any tax. That was what. Otherwise, both of them would have paid tax. You see? So basically half the tax bill.
But isn't the operated subject is a different, I mean the separated organization who make business and have to pay taxes. So, okay,
so you've got a pile of land and jewellery and property and all this stuff, and you put it into, in the 16th century, you put it into what was called a use or a trust. And the legal owner of that trust would have to pay tax, but the beneficiaries who used all this stuff and lived on the land and lived in that mansion and all that stuff, they didn't pay the tax. If you kept it all in the ownership of all of them, they'd have all paid tax. So the idea was you pay less tax. That's how it worked. And they're still used in Australia to minimise tax. We still use trusts. They've closed a whole bunch of loopholes, but you know, people still use it to save money, to save tax money. But you can also form beneficial interests by entering into contracts as well as with trusts. And in mining, there's this thing called the joint venture, which is the principal form of contract creating a separation of legal and beneficial interests. So in a joint venture, you have two or more parties. You each have an interest in the venture, which is around a project, and the purpose of the joint venture is to share the risks. So instead of one person doing it, you have 3 or 4 doing it, they all have a different... So the best example of a joint venture that I can think of is a rock band. Rock bands are joint ventures. Everyone has a 25% interest of any of the revenue, because that's how it works. Unless there's 2 principal songwriters, in which case they earn the... Sorry?
No, I just tell us
It's a contract governing mining or petroleum exploration or production.
the name in Armenian joint venture.
It's a contract between 2 or more companies. And the difference between ordinary contract is that...
No, it's still a contract. It's no different from an ordinary contract. It's just that certain rules have grown up around it because the legal holder of so the project's made up of a tenement and other property that's used to work that tenement. So mining equipment, mining information, and that property is held beneficially by each of the parties to the joint venture. Now some joint ventures it's equal, so it's 25% each, like a rock band. Everyone gets 25% of the income unless someone's writing the songs, and they get the song income separate from the band members, but all of the band, all the music sales and all of the rock concert sales all go split 4 ways if there's 4 people in the band. And the same happens with the joint venture. They split everything 4 ways unless they've decided that someone's going to have 50% and 2 might have 20% each, and then the other 10% goes to the 4th party, right? So it's not, you don't have to have equal shares, is the point I'm making.
It's all about having shared information, risks.
Yeah. So if you've got and they're usually good for really big projects. So the offshore gas projects offshore Western Australia, it costs $80 million to drill an offshore well, because it's like the technology is extraordinary, and we're talking about the drill goes, you know, you have to you might be a mile down underwater, so the cost of drilling from there is just prohibitive. So they share the risks by, so one party might say, well, I've got 100% of this tenement, I'm going to give an interest to 20% interest to somebody to help me defray my expenses. They pay the 20%, I pay the 80%. I haven't had to pay so much, I manage my risk a bit better. In its classic form, each venturer owed fiduciary obligations, which means you couldn't have any conflict with the other parties and you couldn't have any profit, you know, at their expense. So that was the traditional form of it. But that's sort of gone by the wayside now. They only make these contracts subject to good faith, which means they're all honest with each other about things. And the strange thing about a joint venture is you don't, if you've got a mining joint venture, you don't dig the ore out of the ground and take it and sell it to market and then share the money that arises. You notionally take the product. So if you have a 25% interest in a gold mine, you take 25% of the gold ore. You take 25% of the gold ore from the mining, and then you go sell that. You sell it yourself.
25% is not from sales income, but from the ore.
You take the product in kind,
Okay.
and that was originally for tax purposes, but it's now become sort of part of the structure of a joint venture.
Well,
So
if your 25% of the ore contains less.
Well, no, because there's very detailed provisions in mining joint ventures about everyone getting the same grade. You know, everyone getting the same amount, as it were. So, you know, in accordance with their 25, with their participating interest share, it's called.
Then it should be not ore, but concentrate.
Or it depends what the contract says, but in any of these forms, might be gold bars, like it might be finely smelted gold. But you don't ever get cash.
Okay.
So what happens then is that what now joint ventures typically do is they say, we'll get a marketing agent, we'll all notionally take the product, but we'll give it all to the marketing agent, and the marketing agent will sell it and give us the proceeds. Okay.
Interesting.
Now, a joint venture isn't enforceable against the government where your tenure is recorded on the register. So you could have a joint venture here in Armenia, 4 different parties, they've all got different participating interest shares, it all adds up to 100%. But on the register there's only one company. But they have entered into a joint venture with the other 3. It's not on the register, no one can see it, right? Just don't know it exists. That is how miners hide beneficial interests. Doesn't need to be lodged with the government. Government doesn't even need to know about it. And as we had confirmed through our consultations this week, the government's fine with that. Even though there's a provision in the mining code that says if there's a transaction purporting a transaction that says it's transferring a right to somebody else using a joint venture, that, because it's not recorded on the register, that is void, that transfer is void. Well, the state of Armenia doesn't think that that's what it means. That's what he said to us.
Yeah. But I think it's a bit different. Our transfer of rights contract, etc., is a bit different than a joint venture.
Yeah, no, that's what he was saying, and I agree with him.
Yes,
Because I think the joint venture is enforceable against the other parties, but the state has no role in it, so it's not enforceable against the state.
It's about the right that was granted by the state.
Exactly. And that's called the registered interest. And you might have one party holding 100% of the registered interest, and three parties holding the 100% participating interest. And the participating interest is a beneficial interest, because they're not the legal owner, they're only the beneficial owner. Yeah. These things were protected in common law countries by contractual writs, where this is where you sue somebody. You know, I've got a contract with you. That contract's called a trust or a use. You said that you would hold the property for me, and you breached that. I'm going to sue you. The writs were very rigid in what you had to put in the boxes when you filed them, and many of these common law claims under these uses were thrown out by the court because they didn't have the right technical form of document. They hadn't drafted the writ properly, or the factual circumstances weren't known to the common law, so the common law said, well, we can't deal with that because it's not something we can rule on. So people then went to the Lord Chancellor, who was the highest law officer in England, and said, you know, you've got to protect us here because we're getting screwed by this party to the contract that we're not getting our fair share. And the Lord Chancellor started to develop rules called equitable rules, where he said, well, that seems very unfair what's happening under the common law system, so I'm going to be equitable between the parties and do some justice and override the common law courts, because he was the highest law authority in the land. Now, more and more people suffered from common law rigidity, so more and more people went to the Lord Chancellor, and in the end he set up courts called chancery courts, which were equitable jurisdiction. So they gave completely different remedies when you sued under a contract to what the common law did. Common law gave you termination for breach and breach and damages for breach, various other remedies which I don't need to go into, whereas equity gave you specific performance or a declaration as to what the contract meant, or an injunction to stop the party from doing something bad. Okay? And so if you went to one of the courts and you couldn't get a remedy, you could go to one of the others and go and seek a different kind of remedy. But they were all about this distinction between legal and beneficial ownership, all of these disputes. And so in the end, the court, there's a Dickens novel called, do you know who Charles Dickens is? There's a Dickens novel called Bleak House, where there was a piece of litigation over one of these trusts in the chancery courts that goes for 60 years. Like, that's how long it sits in the court trying to be resolved. So the chancery courts got just as rigid and just as hidebound and just as complicated as the common law courts were. So they decided to fuse the jurisdictions. So now you can go to one court and get all the suite of remedies from the court. You don't have to go to different courts.
And how that's called? A court is called?
So those courts are just, in our system, they're just called Supreme Courts. Our system works, you go Magistrates Court, District Court, Supreme Court, Court of Appeal, High Court. Our highest court's called the High Court. I was involved in some litigation last year where we had a party that was very shady side of the contract. We sued them in the Supreme Court for specific performance as well as breach of the contract damages, and we got both. But it was about a dispute under a joint venture agreement. So I guess the point I'm trying to make is that even though we were dealing with participating interests, not registered interests, we could still sue that party. The state wasn't involved in the litigation. We held 100% of the permit. They were buying a 70% interest in the permit. We were selling off 70% of participating interest.
And the state really doesn't need to.
Doesn't need to know. But this is directly contrary to the transparency desires of people about beneficial interests, isn't it? That's why I thought it would be useful to go into this in some detail, because it explains where all this comes from.
Yeah, it's very interesting, but it's still, those are big companies. They're the subject of dispute between them might be of their importance and interest rather than the state's. So it's just granting, leasing the ground, and how you are going to arrange it with.
Yeah.
It's just up to you.
Now, you don't have yet beneficial interest provisions in your code, but you do have various forms of trust-like relationships. You've got agencies, you've got entrusted managers, although the entrusted manager doesn't own the property in the way that in the trust a legal owner owns the property. So I was fascinated by the entrusted manager definition, because it's not an agent, but it's holding property, but it's not the owner of that property in a way that you would be the owner of the property if you were holding it on trust. So the mining code seeks to prevent transfer, I was talking about this before, 22.3 says in the mining code says all transactions and activities aimed at transfer of mining right without consent of authorised bodies shall be void. Now that's talking about registered interests only. If you try and transfer a registered interest without the state's consent, it won't be acknowledged. But you can do it with a joint venture with a beneficial interest or a farm out agreement. You can give someone a participating interest and the state doesn't need to be involved, and they basically acknowledge that they're comfortable with that. I think that's right. I think, as I say here, I think that, and I'd come to this conclusion before we spoke to the government, that the civil code, the transfer of the interest, the participating interest, would under the civil code be an obligation that could be enforced by the parties, but not against the state. So the guts point though is that this means that if someone is on the register as the holder of a mining right, they might not have anything to do with it. They might have given away 100% of the participating interest and just sit there on the register as the legal owner. See what I mean? So that there's no transparency in that at all. But it's the way the mining industry works. And the reason it works that way is because they don't want to have to keep going and getting consent from the state every time they enter into a commercial deal.
One of our former ministers of nature protection owns more than 20 mining sites. When the article was published with the names of these mining sites, of course it's not yet permitted to exploit, but still it's his ownership. He didn't even reject it. He said, yeah, so what? It's a problematic part of industry, and if you are so risky guy, so go and be involved in that section. I'm involved. That's okay. Former minister.
So how did they find out how he owned it?
There was some conflict between him and one company, mining company.
So they went
Mega Gold, and this mining company had some information, and it
gave it to a journalist.
They always have
I kept this newspaper.
So, solutions. How do we deal with the lack of transparency in this? You could have a provision in the mining contract that says if you enter into a farm out or a joint venture, you have to lodge it for registration, or not for registration, but you just have to get it recorded on the register so that people know there's other people owning it. And if you don't get those things lodged and recorded, then the mining operator will be in breach of the mining contract. But a long-term solution, really, you need these contracts. You need to be able to be flexible about managing your risk. And so the industry is going to want them. So the question is, how do we deal with that? That's the fundamental reality of global mining. So we need to take account of it somehow. So I think you could easily lodge the agreements, and then all that would need to be released under freedom of information, the only thing that wouldn't be commercial in confidence would be the names of the owners, the names of the beneficial owners. And then there would be transparency about who was owning it. So that's how you manage that issue. You can create code provisions. I don't really understand, there's some suggestion that we've heard that they're going to create a whole new law of beneficial interests, but that seems...
They are talking about, there are discussions.
Yeah. But I would have thought you'd be better off amending the civil code or putting in a section in the civil code, because that's where all the obligation things are. So they're fundamental to mining. There needs to be safeguards to protect transparency, but and that's really important to get back the trust of civil society that these legal forms are okay and that they are a standard part of doing business, rather than some dangerous thing that's hiding stuff.
Yeah, this is I guess very useful to know for EITI and context.
Yep.
Yeah, there is some sort of rule in the standard, and who apply this standard for starting from 2020, it will be obligatory for reporting. But up to that, obligatory is the roadmap, to present a roadmap, how we gonna come to that point.
This is largely what I presented yesterday. So unless you've got a burning desire to hear about Queensland and WA financial assurance legislation,
If you send the presentations,
I can send them out, that's no problem. I just send it to you and you can circulate it.
You know, one more issue which is very common in Armenia, I cannot get why all companies are registered in offshores. All, I mean mining companies.
Oh, what, sorry?
All mining companies, sorry. All mining companies, I mean those who are involved in the metal mine industry, all they are registered in offshores. Virgin Island offshores, I don't know, somewhere else.
Why
All
shouldn't
of them.
they? Why shouldn't they?
But why should they? What is the,
Because it's good for tax avoidance.
that's why I want to understand
Well,
the
why are you asking?
mechanism, the whole point by point, which it gives to the companies, and which is the non-benefit of the civil society, I mean society and the state, because if the company avoids the taxes, it means that they don't pay enough money for development of this country. So I want to understand point by point why, what the benefits gives the offshore. Is it legal or legitimate benefit for the company, or they just avoid taxes?
No one could set up a company in the British Virgin Islands or the Cayman Islands or Jersey or Guernsey unless the law allowed it.
But they can tax. Can they? Unless
This
the law
country
allows.
can bring in laws to tax those
German
entities, yeah.
recently
They-
adopted
and
a
so
law
so is Britain.
to tax
That's right.
offshores as well.
But there's still a lot of loopholes around the world.
Yes, of course.
And so you're never going to stop people avoiding tax. It's just you've got to make as many things as you can unlawful so you can't do it.
Safeguard.
And you make it unlawful, but you also, you don't just make it unlawful, you also make the penalty for doing it incredibly high. So automatic jail term of a year or something. Now that stops people from doing stuff because they don't want to go to jail.
Yeah, still I think there is a need of deeper research with the examples, and based on the examples to understand.
I do searches
What is
in the
that?
British Virgin Islands all the time. You just hit a brick wall. You can't find. You just can't find. You can't go any further. Do you remember that Panamanian leak? Did you see the interview with the Icelandic Prime Minister? It's hilarious. So this journalist just very calmly sitting across from the Prime Minister, and the Prime Minister's being very kind of prime ministerial and very sober and nice. And the journalist says, "So we see that from this recently leaked information that your wife owns these, and you seem to be a beneficiary of these companies in Panama." And it's just, and he misheard the question, and so he sort of starts to answer it, and then he goes, "Oh."
Really?
Stop dead. I'll see if I can find it. It's very funny. And he just completely caught out, like he's nothing, he couldn't respond. So funny.
And our head of compulsory enforcement had a professor with mentioned.
Yeah? Yeah.
And he resigned. But the prosecution is still in progress. So
The world created a mechanism for all sort of
not the world, people.
criminals to avoid. I mean, yeah, the people living in the world. You can legally avoid the taxes.
Here we go.
It's not criminal. It's
Here you go, I found it.
Germanya'nın inşaatı boş.
big argument with
What
him?
language they're talking?
He's talking Icelandic. It's an Icelandic interview, but the English is underneath. It says, I have your signature here. You mean this is just, just didn't know what to say. It's just amazing. He just
Oh, yeah.
burbled his way through it.
Recently, the Minister of Finance in Russia, who was captured for bribery, when he was like, people entered into his room and said like,
Yeah,
okay.
you're done. Yeah.
He started laughing hysterically, like he didn't believe, like he thought this just.
Oh, they thought they were joking?
Joke by the
KGB.
people. Hey guys, you're fucking. And then,
Stop fucking with me, boys.
yeah. But it was serious.
And the president of our neighboring country also in Panama. And his wife and daughter.
Yeah.
And just right after this Panama Papers appeared, they started war.
Yeah.
Shift
of attention.
attention over there.
Yeah.
That's what I reckon. I think you could do a great sketch, like it'd be a very dark sketch, but you could do a very good sketch of a mining inspector going to a mine like Kajaran and them walking around just doing this.
Have you been there?
I can't see anything.
Very
Can't see
sailing.
anything, nothing here.
Very-
This all looks fine to me.
Very sailing.
Yeah, that's
Isn't
right.
it
Have you been
nice,
there?
like-
There doesn't seem to be any tailings dam anywhere at all. I can't see
You know,
anything.
the biggest.
Ah, it's all nonsense.
The biggest sailing Kingston region, not Afghanistan,
Yeah, in Armenia.
It looks like a blue-green nice lake, and the Iranian tourists who come from that part.
I think it's
from
lovely.
Iran, yeah, they make photos.
Look at the turquoise lake, people.
Yeah,
And
they
one
say-
of our taxi drivers said one day to Iranian, yes, it is the Sevan Lake, we already arrived, but it is a weekend, that's why the hotels were
swim.
closed. Then he remembered
It was the mine.
the number of the car and reported to the police.
People take selfies around that tailing, like it's a nice exotic lake.
It's hilarious. The dam I was telling you about yesterday, the Stroke and a Half Dam in Mount Morgan, that's clear. It's like, it looks like it's fresh and beautiful, but it's as acidic as hell. So do you want me to do this? I mean, there doesn't seem to be a lot of point.
Yeah, I don't think.
'Cause-
Unless Arthur has questions, because we
No,
really, it's a pity you couldn't come yesterday.
That's
We've
not
gone
our
through that
work.
topic quite intensively. But I'll send you the presentations,
Oh,
and
thank you.
if you have any additional questions. Also, you have the papers, right? You have the papers.
Mhm.
There's a lot in there.
And you can have these slides, these ones as well.
Քանի որ էլեկտրայի մասին խոսեցել ենք, եթե ինչ-որ cover չի եղել, հարցեր
Yeah,